May I please, Your Lordship?
Yes.
My Lord, I will require a short accommodation in item number 25.
Item number?
25. Your Lordship had taken up this matter. This matter pertains to Lokayukta, and the learned AG is also here.
Ah.
I will require a short accommodation. I wanted to file my reply, Your Lordship. But on the last occasion, Your Honorable
we don't.
Honorable Justice.
And when we have got the AZ here, then obviously you cannot say that. And why on earth you didn't put a circular notice?
I don't because there was this matter was not fixed as such. I am in Delhi. I came up yesterday. I came to know that this matter is listed today.
Okay.
And I had a talk with the additional AG also. I informed him that let's please brief the learned AG that I will be seeking an adjournment.
Like this, that.
My lord may put it after any day after 8th of December, 8th of September.
Strongly object to this for particular reason.
Mr. Advocate General, there is no stay now.
There's no stay, it's fine, madam. But
there is no stay.
What's happening is we completed our pleadings on 3rd June. So it is 3rd September, 90 days. In between, they had taken time saying that they want to file a rejoinder. That was sometime in August.
Your Lordship, when vacating the stay, directed the state government.
Just wait.
Sir, sorry.
Just wait. So they took time for filing of return. So in my counter, I made certain serious allegations of it. And even the selection committee has done their job. Each one has recommended the same candidate. And after the selection committee consisting of the constitutional authorities, including the former Honorable Chief Justice who has been elevated, the Honorable Chief Minister, the Honorable Speaker, all this has been done. Candidate has been appointed. Now, they've been releasing a lot of things in the press as though the state has done something abnormally wrong. They've even gone to the extent of alleging in the petition that we are playing a fraud on the people by making this type of appointment. They can't just get away, keep this clinically alive and not come to participate in the matter. I have only one humble submission to make. He wants to take a date that's his heading. I want to complete my submissions today, very briefly. And then he wants to file a rejoinder, whatever it is, it can be heard on video, we will participate there. So that our job is done today. It's very brief, I won't take much time. Only two issues are there. One is as far as the appointment of search committee, it consists of the Advocate General and the Chief Secretary. We have said in that.
But Mr. Advocate General, I remember earlier there was another matter, no? Where there was a challenge to the rules the act or the rules they have made.
In fact, this is the very same matter
But it's the same matter.
where they have challenged section 3, that particular provision wherein the search committee, they said, consists of these two officials.
I vacated the stay order.
I was there, I was present.
This matter only.
This
Yes,
matter-
yes, my lord, your lordship may take it up to order of 2nd of April.
That was heard at length, that's why I'm saying. Matter was
2nd of
heard at-
April.
I won't take much time, I'll wait for my turn today. I'll make my submissions. He can make his submissions whenever he wants, we can be heard on video, there's no difficulty.
But the problem, Mr. Advocate General, is we normally don't sit. And I said, if it was a single bench, I could have very well carried it with me. But we don't know when both of us would sit again.
My lord, it's like
That's
this.
the only difficulty.
We will have this problem with every bench. Suppose the matter is not heard. That's why I said your lordship has actually heard this matter.
But if I allow him to argue on some other day, then obviously it goes outside both of us.
He can argue whatever he wants.
And if it was taken up last week, we could have very well taken up this week
Yeah.
also.
In fact, they said that they want to file a rejoinder. In fact, pleadings were complete initially. Then they said they want to file the rejoinder. After they said they want to file the rejoinder, they were given time. Again, it is coming for the same purpose. My humble submission is only this. He has a difficulty that is up to him to take the necessary steps. But as far as the state is concerned, in a case like this, you can't keep on taking dates after the pleadings have been fixed. Therefore, my humble submission is, give me just a few minutes, I will finish off my matter. Thereafter, he can make written submissions, whatever he wants.
So, Mr. Advocate General, we have some difficulties in keeping this. See, the problem is if we do this, we won't be sitting. If Friday was also a working day, we could have put it the next day also for hearing. But tomorrow that is not a possible date, so it will be very difficult, Mr. Advocate. If
We will
we
wait for a chance,
granted
my lord.
adjournment today, means if we hear you, then the matter remains parted.
I am saying today I will take not more than 15 minutes. I will finish my case.
We have no problem in giving you the whole day also.
So then,
It is always a pleasure to hear.
whichever date it comes, your lordship can take it up. I have no problem. Wherever I am, either I will come or it can be heard through video.
Okay, we'll do one thing. You take a seat. We are not adjourning it now.
Right.
We'll take a consideration. We'll hear you if necessary.
May I please, your lordship?
It's
Your lordship is keeping the matter?
Yes, we'll hear him and
for the
then
turn.
take it up again. We'll see.
Meet please, your lordship.
Yes,
Lordship,
ma'am.
I'm looking for VC, your lordship. I beg to mention item number 27, your lordship. You would like to come down physically on 8th of October, your lordship.
What?
Item
I
20.
beg to mention item number 27, your lordship.
And you want it?
Lordship,
On consensus.
we want 8th of October, your lordship. We'll come down physically, your lordship.
I hope you'll be okay.
We'll have it. Is there a stay?
No.
No stay, lordship.
Then Gauhati councils, no problem. They'll come any day. We'll have it in the month of December.
Lordship, October, your lordship.
No, nothing doing. 8th of October, this is a winter vacation going on in Gauhati. You want to come out here? It cannot happen. We'll have it after that. Have it on 27th of October. At the request of the Learned Council.
A little earlier, your lordship, than 22nd, 23rd, your lordship.
When?
22nd, 23rd.
No,
your
no,
lordship.
27th. During Diwali time, come over.
Lordship, there's another matter fixed, your lordship, on 27th, lordship. That is why.
Okay, we have it in the month of November then. At the request of the learned counsel appearing on behalf of the appellants, matters stands adjourned to be listed on 19th of November. Mr. Ali Ralu, the counsel appearing on behalf of the respondent, has no objection. Yes, Ms. Jimomi. Oh, the same matter. Many counsels. Okay.
Yes, my lords, I beg to mention item number 22 and 23. Lordship, here, the arguing counsel, Pinky Anand, she's in bereavement. 23 and 24,
Senior counsel.
senior counsel.
So senior counsel, we don't grant adjournments.
Lordship,
You
she's
must
in
be aware.
bereavement, she's the arguing
Okay,
counsel.
put here.
She's in bereavement, Lordship.
So
Lordship,
there can be an
Lordship,
adjournment on senior counsel.
Lordship, I'm making a mention on behalf of them.
What is this problem? Yes, Mr. Iralu. What is the issue here?
Issue here, we have the Safety Act. Now, under that, there are certain regulations have been issued by the Parliament. In one of the regulations, animal has been defined. Now, in that definition, the definition of dog is not mentioned. Using that, the central as well as state, they use that in view of the definition of animal, not prescribing dog or not mentioning dog, the consumption or the sale of dog meat is prohibited. So the petitioners, they have challenged that. The learned single bench is to set aside the notification. Against that, they have come.
Well, at the request of Mr. So-and-so, the learned counsel appearing on behalf of the appellant. When do you want it? I would not adjourn on the ground of senior advocate, huh?
Lordship,
This court doesn't have the habit of
Lordship,
acute difficulty.
Lordship.
Admits that he has difficulty in the matter. And as such, he has some personal difficulties. Accordingly, the matter stands adjourned to be listed again on
15th of October, Lordship.
19th of November.
Lordship.
The full bereavement period would be over.
Lordship.
Any more?
I would like to mention item 12 of today's list also.
Yes.
On the last occasion, I have been directed to file a comprehensive detailed affidavit, okay? For affidavit in compliance also. So it is going to take some time, because I require at least 6 weeks more time, okay?
What matter is this?
12. This to the claims under the senior insurance and Ayushman Bharat. Now, they are the insurance company.
There?
They are the insurance company.
Okay.
Respondent number 5.
Oh, that matter.
Yes, Lord.
Where the insurance, they are not giving the state
Yes.
the money.
As of date, out of 181 CR, they have cleared 105 CR. So some are still pending. So in this regard, the last order, the court has directed them to find an affidavit to break up which hospital has been paying how much amount. But as per what they are submitting is that we want some extension also for that. Find that.
Okay, next week you file it.
Lordship, next week not possible because additionally what happened, Lordship, 5,000 new
Okay,
claims have
next
cropped up.
week.
Lordship, 5,000 new claims have popped up and 60 crores we have to pay, and we have to file the detailed claims with respect to each and every hospital with respect to each claim, Lordship. So that is going to take some more time, Lordship. That is my.
When was the last order passed?
16th July, Lordship.
16th July.
16th July.
Lordship, that day it was.
You
also-
want it next day?
No, Lordship, some time will be given, Lordship.
How
Because
much?
additionally, Lordship, in the website, some claims were not visible
You
previously.
have, Mr. Counsel, you had no problem in taking the premium. Isn't it? And now while giving these details, you have a problem.
Lordship, we comply, Lordship. Actually, Lordship, in the website, some claims were not visible to us. After the last order, Lordship, this has been
When
resolved.
do you, okay, when do we fix it? We have to fix a date.
Lordship, it is in October.
Okay. It has been submitted by
E. Kakoti,
A. Kakuti appearing on behalf of,
respondent number 5.
who is he?
Future Generali, private insurance company. FGI. Future Generali in India.
Appearing on behalf of the respondent number 5, that the process of preparation of the affidavit is going on, and it would take some more time to file the affidavit, taking into account that further details are required. He therefore submits that the affidavit would be filed without fail on or before 13th of October 2025. List the matter on 15th of October 2025. Any more?
Yeah, please, Lordship. My lord, allow me to mention item number 28 and 29. In both the appeals, I'm appearing for respondent number 1. If this matter can be adjourned for 2 weeks.
Lordship, the rate appeal, item 28 was admitted only last week on 27th. I'm filing by power. Accordingly.
Oh, that matter,
Yes.
Yes,
where it is covered by that judgment.
No, Lordship, yes.
The-
So
the
now it is
versus
listed
Emasa
together.
judgment.
Yes, it is listed together, but then we are kindly announced the filer my power also. Accordingly.
You don't need to file a power, you are a senior counsel.
No, my junior, I'm sorry. I'm sorry. I'm wrong.
Okay, when do you want it?
after 2 weeks, my lord.
At the request of Mr. Takakichu, the learned counsel, appearing on behalf of the
Respondent 1.
respondent number 1
1.
in both the appeals.
My lord, yes.
The matter stands adjourned to be listed on. When do you want it? 12th November. 12th November for hearing.
Yeah, please, Lordship. Lordship, I pick commission, item number 4, 5, on behalf of, my friend Gauhati.
Which items?
4,
4.
yes, my lord.
Then?
5,
Yes.
6,
Then?
7,
Then?
8, 19, and 21.
We will look when the matter is reaches. These are
My
real
lord,
matters.
Lord, friend is.
We'll see if you are also a central government council. You can very well do it.
My lord, I pick
Prayer
commission
rejected.
item number 14.
All prayers rejected. We will look when the matter reaches. Give us the file.
For motion, item number 1.
How long he has been inside?
In this matter, the detainee is undergoing detention right now.
Under which section, under which law? P10 DPS,
Yes,
NSA,
NDPS. NDPS.
P10 DPS. You are inside already.
Yes, yes,
And then also you have been put inside.
yeah. In this matter, the alleged accused, Lam Kun,
Okay, madam, when are you going to file your affidavit and bring your records? You have produced the records next week. Why? It's a case of preventive detention. He's already there inside. You have put him, this goes absolutely against the law of the land. So, let it be next week. Produce your reports.
Your Lordship, there's the detention order, which has been extended, is due to expire on 20 September 2025.
20?
September 2025.
No, don't worry, we are having it next week, next
Oh.
Wednesday. So she produced the records. She doesn't need to file the affidavit. If she wants to file an affidavit, liberty given. Don't file the affidavit, that is your lookout. But produce the records. Issue notice. Making it returnable on 10th of September 2025. Ms. So-and-so accepts notice on behalf of the respondent numbers 1, 2, and 3. And where is Mr. Nugli? Yes, you are number 4. Mr. Jed N. Nugli appears on behalf of respondent number 4. Extra copies of the petition be served upon them during the course of the day. The petitioner hearing is agreed by the action on the part of the respondent authorities in putting in issuance of the detention order as well as the confirmation order, whereby the petitioner or petitioners, petitioner, no, whereby the detinue have been put under preventive detention under the NDPS Act 1988. It is the case of the petitioner that the petitioner has already been arrested.
Yes.
And is in judicial custody, and therefore applying the law as laid down by the Supreme Court in the case of Udiram. Will that judgment, Udiram? Udiram Konongjo Singh versus State of Manipur and others, reported in 2012, 7 SCC 181, the respondent authorities could not have passed the detention order. The respondents are directed to, the respondent numbers 1, 2, and 3 are directed to produce the records on the next day without fail. This court further grants the liberty to the respondents. Numbers, respondent, who is the authority who has respondent number 2 to file affidavit if so advised in support of the detention order on or before the next.
For admission, item number 2.
Oh, this matter. This is the vehicle. Which one?
Kohima.
Okay. That day I was telling our new Chief Justice the 2 things he would never finish. One is our High Court and the other is this Dimapur Kohima Road.
Yes, Lordship. I'm appearing in this BL since 2019. I think I had appeared around 70 times. I have been to the site more than 30 times at the desire of this honorable court to go and check. But if not for this honorable court,
Because last time when I came in the month of April, there I passed an order. There was some April, yes, this is the order 2-4. There were certain problems which were there. I have directed. Have you seen that order of 2-4-2025? I get specific instruction how to do, what are the things which is required. There were certain problems which were there. Have all been resolved?
progress has been made thereafter.
Huh?
Progress has been made thereafter.
Okay.
A lot of progress has been made thereafter, and after your lordship made it point-wise, that has been followed. So lordship, the last order, lordship, at least the for point of concern today, 16/7/2025, effective. Last effective order,
The Learned Council is directed to furnish copy of the affidavit.
only 16/7, lordship. Effective order is on 16/7,
16/7.
lordship. That has to be. Thereafter, the last 2 occasions, the matter, there was no effective hearing, lordship.
But who was appearing on behalf of the contractor here? Mr. Jami, you are paying?
Lordship,
The contractor in the this the nearby to the what is that the third is part C. This
Yes.
one
it
nearby
falls
to the
within
Kohima.
My lord, it falls within the state government.
KMC.
Huh?
This falls not within it falls within the jurisdiction of the national highway, state government, not with the contract.
No. Just beyond that. Beyond that, there are three packages. No?
Yes.
This is package C or package 3. The third package.
Yes.
The third package, who is the contractor? You are there.
Yes.
Now, what has happened? Any chance of completing?
Also.
I think you gave an undertaking to finish it off in the month of September.
Lordship. Now, as per the commitment of the NHITCL, now there has to be a certain upgradation of that the stretch, the landslide. So we have proposed for piling because around 15 feet of the road has sunk. So that proposal has gone and the NHITCL has given a commitment that the matter will be taken up with the concerned authorities.
This is for that landslide area.
Yes, that near the bridge. Snow protection, yes.
And what about the earlier area we don't see that bridge being constructed?
Bridge, the Bailey Bridge.
Huh?
The Bailey Bridge, yes, Lordship. On this issue, there are certain components which we have ordered from Gujarat, which will be reaching in a day or two, and we will complete the work, Lordship.
It doesn't seem that we are already in September.
Lordship.
How on earth will you be completing in the month of September? Isn't it the last they made given an undertaking that they will be completed by September?
Yes.
Okay, this landslide area, taken note of, this is out of natural causes.
Yes.
But what about that Bailey Bridge?
Yes.
It
Because-
remains the same.
Yes, in fact, it was flagged on the last occasions also. So let us hope that we complete within September.
Lordship.
So
yes.
since it still remains, so let us hope.
Lordship, the additional components which is required, Lordship, that has to be transported from Gujarat. We have already made the order. It will be reaching in a day or two. And as soon as it reaches, we will complete it, Lordship. We have requested manpower to handle the execution of.
Because from 2022, where I've been seeing that the bridge is lying in the same
Yes.
state of affairs.
Exactly, doctor.
I hope it doesn't rust it down.
No, Lordship.
Huh?
No, Lordship. We have taken the stock of the whole structure, Lordship.
What do you say, Mr. Takawasa? We adjourn the matter to some other day.
It's up to you, Lordship. Up to you, Lordship.
Is any order required to be passed for this court to give more effect to the implementation? No.
Let it be the next week then, no problem.
Or should we have it in the last week?
Fine,
I think we have it in the last week. Last week, I think Manish is coming.
yes,
Lordship.
let it be after 2 weeks. No issue.
Let it come up on that day, because then I think
Yes, Lordship.
something more.
Yes, we can update the program. On the progress.
Rest, there is no problem, Mr. Zamir, as regards those implementation, the district administration, everybody is helping you out. Have been done, huh? Okay.
In the meantime, Lordship,
Hmm.
my humble request, let respondent number 19 file the status report on the next day. Status of his work,
Which one?
for respondent number 19 for slope management. Because,
As regards this. law.
yeah, because he has been allotted on other place,
Have you allotted the contract to them?
slope protection.
I don't think so.
Slope protection. So Lordship, rockfall barrier is an issue, but we can take up on the next day. There has been a casualty also, so inquiry, so certain affidavit has been filed also by the government, so that issue has been looked into. So to assist the court, let respondent number 19 be directed to submit the status report
in respect of the works executed by.
So by responding to my not 19, because he is working in several places, he's doing
Respond
a-
number 19 is the NHIDCL.
no, no.
McCaffrey.
That he,
I'm Brandon Girl, 15 for package number 3.
you are package number 3. And
Yes.
you are package number?
But Lordship, he's doing the slope management in all the packages.
Package 1, package 2.
And what has happened in the package number 1? What has happened? It is becoming bad day by day. By the time it finishes that portion again, you may have to keep on doing work.
Lordship, that issue will be considered next. I'm serious about that. We will deal with that on the next week. Very better case. Thumbs up.
It has been submitted. Heard Mr. Takamasa, the learned senior counsel, who is also the amicus curiae duly appointed by the court. We have also heard Mr. Yunti Chong, the learned additional advocate general. Mr. T.B. Jami, the learned counsel who represents the respondent number 19. Mr. N. Mujoy, the learned counsel who appears on behalf of the respondent number 15. Mr. Muajami, the learned counsel who appears on behalf of the respondent number 6 and 7. And is the authority engineer here? You are there? And you are Mr. George. You are not the authority engineer. Okay. Okay. And during the course of the hearing, it has been submitted that in the whatever this area would be the Chinese, which one? Where you would be granted the contract?
Change
164, the landslide is there.
164, the landslide.
Chinese 164.
Yes.
That in the landslide area, which is specifically from Chinese,
164.
no, it cannot be 164. Yes, in the sinking area at Chinese 164.
Yes.
There has been certain the work is the respondent number 19. You are 19,
No, I'm 15.
Respondent number 15 is supposed to be given a work order. Have you been given a work order or not?
No, Lordship, I'm concerned with the construction of the road. So the work order is already there with me.
Oh, so there,
Just some upgradation in the work.
Ah,
When they find
yeah.
it.
So there's a specific work order to be issued for
Lordship, because there will be addition.
additional, no?
Yes.
Submit. And what do you have to say, the authority engineer? Are you going to give a work order for this additional work in Chinese 164?
164, one side isn't completed. The right hand, the land acquisition is over there, but it is over now. So right hand side, left hand side work will start.
No.
Lordship, ultimately, it is the NHITCL who should be adopting the work. Not by the authority engineers. Some proposal must have been there, subject to approval by the NHITCL.
Are you going to issue a fresh work order for additional work?
Yes, Lordship, I'll get
Because
it.
unless you issue a fresh work order, how can you do?
Yes, Lordship. We'll look at.
Or have you already placed the requirement for going ahead with the work?
We'll look at the Lordship.
And Mr. Mujoy, what is your instruction? Have they issued any work order
No,
or
Lordship.
are they required to issue a work order?
They are required to issue a fresh order because that is
Fresh work
that is
for
not
the
within the
additional-
scope of the work. That is not within the scope of the work.
Mr. N. Mujoy, the learned counsel appearing on behalf of the respondent number 15 submits that in Chinese number 164, which is the sinking area, on account of a landslide,
Hello.
there is a requirement of issuance of a fresh work order for the additional component.
Lordship.
Mr. Muajami, the learned counsel who appears on behalf of the respondent number 6 and 7, admits that he has no instructions in that regard. Full stop. We have also heard Mr. T.B. Jamil, who appears on behalf of the respondent number 19, who submits. Before that, you write, huh? This court also inquired with Mr. Mujoy, the learned counsel, appearing on behalf of the respondent number 15, as to what is the progress of the remaining work, taking into account that they had given an undertaking to complete the work by September 2025.
Lordship.
The learned counsel submitted that there's a progress in the said work, and it would be likely to be completed.
Lordship.
This court also inquired with Mr. T.B. Jamil, the learned counsel, appearing on behalf of the respondent number 19, who have been entrusted with the work of slope management in respect to the 3 packages.
Clearing of clear slope and installation of rockfall area. Installation of rockfall.
Slope management will include everything.
No, different contract. Different contract. Slope
Management of in respect to 3 packages, as well as
rockfall areas.
Rockfall areas. And as well as barricading of the rockfall areas. He submits that the work is in full progress. Mr. Takamasa, appearing on behalf of the amicus curiae, the learned amicus curiae, Mr. Takamasa, submits that an affidavit on behalf of the respondent number 19 would be beneficial in adjudication of the instant proceedings, so that the progress can be duly noted. So taking into account the above, lists this matter again on 24th of September 2025. On the said date, Mr. Honor, before the said before the said date, the respondent number 19 shall bring on record the present progress. The progress in respect to the work allotted to them. Mr. Mujoy shall also, the respondent number 15 shall also provide an update before this court as to whether any additional work order has been issued and what is the progress in respect to the remaining part of package 3, which is supposed to be completed as per the undertaking by September 2025. List accordingly.
Obliged, Lord.
For admission, item number 3.
Yes, Mr. Jimmy.
My lord, in respect of this PIL, sometime in late July, about 100 meters stretch of road.
This is the other one.
Yes, the Kohima to Mount. Kohima to Mount. They gate to Mount. So in the month of July, late July, a stretch of 100 meters just below the Kisama gate, it collapsed completely.
Oh.
And the road was completely cut off. So because of that, there was not much progress in the completion of the project. Now, Your Lordship, on the last occasion, the NHABCL also put forward a proposal and they made a submission that to make this road a durable road, in addition to the restoration works, some land would have to be acquired. An affidavit has been filed by the state today, and the land has been acquired currently. I speak the affidavit is on record, So the additional land which is required for making the road a durable road has been acquired. So in that view of the matter, my lord.
So has it been handed over? Who is the contractor? Who is paying for the contractor? You are the same 15? Yeah.
No, Lordship.
Or is it Mr. Mujoy enjoying the privilege of having the main contractor being the man?
So, Your Lordship, as far as this latest development is concerned, it will entail a new contract. Land has been acquired, it will entail a new contract.
So the road will go in another direction from the existing.
In the same area, but land has been acquired on the hillside. Additional land has been acquired on the hillside. So what the NHABCL needs to do now is to prepare a concrete action plan to make the road a durable road. That part has not been done. That needs to be done.
What about the remaining part of the work?
The remaining part, Lordship, we have almost completed all the work.
You were supposed to complete last time only.
Yes, Lord.
Jimumi has got the attention of that out of the entire stretch, 26.97 kilometers, 26 of the road is yet to be completed. Has the work been completed?
Lordship, that-
26.7 kilometers, Mr. Jimumi?
Some portions has been completed, but the portion towards the second portion
Because
towards
it
the
was
Gauhati.
supposed to be completed by 31.5.
Yes, madam.
What has happened?
Lordship, I'm here to receive instruction from the client, Lordship. So shortly.
Cannot be. This was given from the month of May. You have no instructions.
No,
Means
Lordship,
I think
because of the.
I think your client has kept you high and dry.
Lordship, sorry for indulgence, Lordship. No, because of the collapse of the road also. We
Understood.
Lordship.
The road is the road is not 26.7 kilometers. You were supposed to complete by 31.5. This was an order which we had passed on 33.4.
Lord.
And today we are seeing at the same stage. Yes, Mr. Muajami. It seems the contractor you have given the work is not doing anything. Forget about the landslide area.
Yeah.
Apart from the, have you done anything? We are made to understand, on one hand, that all over India, the national highway or the NHIDCL have been doing or making huge strides. But the fact that for the last 3 years, you are not in a position to complete 26.7 kilometers, isn't it a matter of shame?
As per the instruction, because
You come here.
because of the weather condition, Lordship, the
Weather
contractor.
condition is only 3 months or 4 months,
Lordship.
not the entire months. But the fact remains that in all other periods,
Lordship.
you are not in a position to complete the work of 26.7 kilometers. And both the NHI and NHIDCL boast about that we are making huge strides. Isn't it something very shameful? Or is it that the fact that NHIDCL is not doing any work out here is not known to the people in large? It seems something like that. It doesn't take 26.7 kilometers to do. When this order, this this PL was taken up in the year 2022, when Justice Serto was there,
Lordship.
then
Lordship, we have been giving instruction to the contractor, Lordship.
are you also having a competition that the Kohima, Dimapur Kohima road will beat it?
Lordship, the early contractor.
Here the
was-
package trees,
Yes, Lord.
package, it's the size of package tree.
Yes, Lord.
Then
Lordship, the earlier contractor was terminated, Lordship. My colleague appreciated the contractor on the field is new, Lordship. He has newly been engaged. And
he
we
gave
have been giving them
Mr. Muadami,
reminders.
he gave an undertaking on 31 that he'll complete it by 31.5. What has happened? That's state of affairs.
Lordship, if I may.
I think NHIDCL has no intention of doing anything as regard to work. If there was a zeal on the part of NHIDCL, they could have completed. What is the area from Dimapur to here or to Maugate? How much? What is the area? If from Maugate to Manipal, the road can be made proper, why on earth you can't do this?
There were some circumstances which we were.
You have no problem. The road is there. Forget about this landslide. How much, Mr. Jimumi, what is the area for this? How much?
100 meters,
100 meters. And they are taking the advantage of these 100 meters. And it must have fallen recently.
July.
Oh, then, and they were supposed to complete by 31.5.
This road has been temporarily restored, Lordship. The light motor vehicles and flying vehicles.
This is happened in the month of July. They were supposed to complete by the month of May. What have we done?
There was itself.
It's very disappointing. I think we should record it in the order that the NHIDCL, NHI, they are absolutely disappointing. If you see your website out there in the Ministry of Home, what we call Roads and Transport, MOT, they're boasting out there, we are completing 3 kilometers, 5 kilometers, 10 kilometers a day. And you can't even complete for the last 3 years, you can't complete this road of 26.7 kilometers and this another 60 kilometers from down.
We were compared to the now we have engaged the new contractor. And in the middle also, we have also engaged two other contractors for short-term maintenance also. Now, unfortunately, this incident has happened also.
So why don't you say that we are not in a position to work in Nagaland? Put your hands up and say that no, Nagaland or Northeast, we are not going to do any work.
We are consistently monitoring.
You have been issuing work orders, this, that, everything, but you are not being in a position to complete the work. Very sad. Who is the authority engineer here?
We have engaged now, but there is it doesn't find well with the Singham also.
We'll ask the authority engineer to appear. This is not done. The very sad state of affairs. Otherwise, they should give it in their website. We can do many works, but not in Nagaland.
Otherwise, we have engaged.
People also know what is actually happening. Isn't it shameful? The government of Nagaland has been providing you the land, everything has been done. There's no problem with the right to way. District administration have performed all their work. But for you, you are not doing anything. I think we should record it in the order that NHIDCL is incompetent.
Ultimately, we appreciate those.
There's nothing to appreciate. You are not even taking action against Mr. Muza's client. They were supposed to complete by 31/5. And it is as if their undertaking is as if it is a routine matter that we every day will give another undertaking. There's no value. And what can you do? We don't do it. That's all. Isn't it, Mr. Muza? You have no value of this undertaking. You can't complete it. And after the undertaking is over, then this person. I think that your client should be appearing in person. Because as he's not taking the benefit of his lawyer and or the representation of a lawyer, I think the person should appear in person. Next week, let that person appear. Your managing director, let him appear in person. Because he's not giving you instruction. Undertakings are given in galore, nothing to do with that. We have it next week and let your person come and appear. Because he's not giving instructions. I heard Mr. Ejimomi, the learned amicus curiae, Mr. Muajumi appears on behalf of the NHIDCL. Mr. Imti Imshong, the learned additional AG, appears on behalf of the respondent state of Nagaland. And Mr. Muajumi, Mr. N. Mujoy appears on behalf of the
Respondent number 13 and 14.
Respondent number 13 and 14. Mr. Ejimomi, the learned counsel, submits that in that entire stretch of 26.7 kilometers, in a stretch of 100 meters, there had been a landslide.
Collapse, complete collapse.
Landslide. Landslide. And resultantly, the state had provided an alternative land wherein the road can be constructed. He further submitted that in view of the landslide, the entire stretch of 100 meters have collapsed. The learned counsel, amicus curiae, in addition to that, also submitted that there may be a requirement on the part of the NHIDCL for issuance of a fresh work order in respect to construction of that 100 meters of road. 100, I think it may be more now.
Plus minus.
For that area of the road, which had to be freshly constructed. This code further takes note of. Now we further take note of that when the matter was taken up on 3/4/2025, an undertaking was given by the respondent number 13 and 14. To the effect that the road
No,
of
only 13, Lordship.
respondent number 13, that the road will be completed by on or before 31/5/2025. This court inquired with Mr. Muajumi, the legal counsel who appears on behalf of the NHIDCL, as to what is the progress of the road. Yes, what is the progress? What is the status? How much they have done? Because earlier they had done only 26.
70%.
Submitted that 70% of the work have been completed. This court further inquired with Mr. Muajumi as to whether any action has been taken upon the contractor, taking into account that the contractor have, in spite of giving an undertaking for completion of the work within 31/5/2025, have not been able to do so. This we also have duly taken note of that the landslide which had led to the entire collapsing of the road is only in respect of 100 meters of area, a 100-meter stretch of land, and which only happened in the month of July 2025. The counsel appearing on behalf of the NHIDCL, however, had no instructions in that regard. This goes further inquired with Mr. N. Mujoy as to why the work of 26.7 kilometers could not be completed within the time committed to be completed. He further submitted that he has no instructions in that regard. It appears, therefore, that both the NSIDCL, the counsels appearing on behalf of the NSIDCL, as well as the counsel appearing on behalf of the respondent number 13, have not been provided with adequate instructions. In other words, it appears that both the NSIDCL as well as the respondent number 13 have not taken up the issue which is being are not serious with the present proceedings, and as such, their counsels have not been provided with the instructions. Under such circumstances, this court, therefore, fixes this matter again on 17th of September 2025. On the same date, a competent person from the NHI judicial shall be present in person to apprise this court as regards the status of the work and what steps NHIDCL is taking for the completion of the road in question. This court further directs a competent authority of a competent representative of the respondent number 13 to be present in person so that this court can present in order to apprise this court apprise us as to when the work of a stretch of land or stretch of road when the work of 26.7 kilometers would be completed. This court is compelled to direct personal appearance of these persons on account of breach of the undertaking by both NSIDCL as well as the respondent number 13.
I'm glad to the order dated 13 August regarding the acquisition of the street of land. So acquisition has been already completed.
I've said that.
Yeah. Which
The land has been given, I've written.
Yeah, we file an affidavit also.
No, I have said it, the land has been given.
Okay.
The thing is nothing like that. Both NHIDCL as well as these respondents. These respondents, you are paying, who is this respondent from? Mr. Mujot? Where is this respondent from?
Local contractor.
Local contractor.
You are not interested in doing something good for the state of Nagaland? I would have understood some other contractors outside not interested. But if a local contractor is not doing it.
Lordship, there is a, sorry for not informed.
From a local contractor, you are not getting any instruction. Isn't it the most shameful thing? If I was the lawyer, I would have even handed over back the brief. You don't need to appear. You see, Mr. Counsel, NHIDCL gives no regards to you, and as such, no instruction is being given to you. You appear, you don't appear, not necessary. You're of no use. We are sorry to say this, but you are of no use because when your client does not feed you with the instructions, isn't it the most shameful thing for a lawyer? You do it. That is what you make yourself available through video conferencing.
For admission, item number 4.
Yes, what is this?
Hello, I take the vision on behalf of my friend, Gauhati.
Okay, let us see what has happened. In terms with the order, Mr. So-and-so shall also place the instruction as regard the acceptance of utilization certificate by the central government, which have been submitted by the state government as ordered by the order dated so-and-so.
Lordship, I'm respondent number 3, Lordship. The Body Department for implementing the state scheme, Lordship. I have filed my.
Oh, this is pertaining to this one, huh?
Lordship, supplementary nutrition program, Lordship.
Yeah. This is a Poson tracker. Yeah, introduce a supplementary nutrition which is represents so and so for males. We have been asking this Mr. Gauhati to get the instruction as regards acceptance or otherwise of the utilization certificate submitted by the state of Nagaland on 2/4/2024. And till now nothing has happened.
Lordship.
And Mr. Gauhati doesn't appear. And this is not being done. So we direct this person to appear, na?
By order dated 18/6/2025.
Then again on 5/2/2025, some orders passed. It is seen. Heard Miss So-and-so, the learned counsel appearing on behalf of the prisoner. Miss A. Santam appears on behalf of the respondent state of Nagaland and.
Respondent number 3, Lordship.
And Mr. N. Niguli appears on behalf of the central government appears on behalf of the Union of India. It is seen that by an order dated
11/12/2024.
By an order dated 11/12/2024, there was a direction issued upon the central government council to obtain instruction as regards the acceptance or otherwise of the utilization certificates submitted on behalf of the state of Nagaland, which was appended to the affidavit date filed before this court on 2/4/2024. The matter thereupon have been listed on various occasions. Today, it has been submitted on behalf of Mr. Nugli, the learned counsel, learned central government council, that Mr. Yangavati is not available. We adjourn this matter today and fix the matter again on 17th of September 2025. We direct the central government, who is the respondent. Central government is respondent number 1.
One, Lordship.
By name. We direct the respondent number 1 to provide us the utilization certificate without fail on the next date. Mr. Nugli, the learned CGC, shall duly intimate Mr. Yangavati, the learned CGC, about the present order, so that there is effective compliance.
Published, Lordship.
For admission, item numbers 5 and 6.
Well, yes, so
what is this, madam? What is this matter?
These are two analogous matters, Lordship. One is seeking implementation of the menstrual hygiene scheme in the state, Lordship, and the other PIL concerns the adolescent health-friendly clinics, Lordship, which are supposed to be implemented through the district hospital, community health centers, primary health centers, and the sub-centers.
So what is required to be done?
No, Lordship, with the direction from this court, Lordship, the state has filed its affidavit, Lordship, regarding showing the scenario of the implementation, Lordship. Lordship, they are saying that they are implementing only in 3 districts as a pilot project. I don't know, they have rolled out, Lordship. But then this is not in compliance with the guideline, Lordship, because these schemes are in existence, Lordship. It's been implemented since 2014, Lordship, and prior, Lordship. Now, for the state of Norway, with the intervention of this court only, Lordship, the state has started gradually its pilot project in the state of Kifri, during the pendency of this, the petition with the direction from this court, Lordship. So my submission is this is not in concern with the guideline, because as per the guideline, it has to be, initially, the focus was to be implemented in the rural area, Lordship. But as per the mission steering group decision taken in the year 2012, it has to be, it's covered even for the urban area, Lordship. So this is a need of the hour for the, especially adolescent girls, because this is specifically focused on the adolescent girls. Lordship, and it is not a case where there's a lack of fund also, Lordship. Central government to this effect has filed its affidavit. Lordship, giving in their affidavit, Lordship, they have highlighted the amount, Lordship, that has been already released for implementing the scheme and the project, Lordship, which is quite huge, Lordship.
Now, first is this PL 23.
Lordship.
23 relates to the scheme of Rashtriya Kishore Foster Karikram. Have to be provided, sanitary napkin have to be provided to adolescent girls at a subsidized rate.
Lordship, yes.
And at the same time spread awareness to the adolescents group in different states and union territory.
Lordship.
So that is the basis on which PL 23 is there.
Yes, Lordship,
You have
yes.
done it?
Yes, Your Lordship, we are filing that.
Nothing in it.
We are doing it.
This cannot be on pilot.
No,
This you are
Lordship, that is the
implementing.
pilot, Lordship. But as far as the scheme is concerned, even the school education department is also part of it. They have set up vending machine in schools. So it doesn't only concern us, Lordship. For us not to overlap the scheme, to implement the scheme, Lordship, we are in constant touch with the school education department. Whatever part they have to do, they'll do, we'll do our part.
So what is
Lordship, I
required
filed
to
an
be
affidavit.
done
I
as
filed-
per this scheme?
Lordship, I have explained in my affidavit, Lordship, dated, I filed it in the month of May.
Now, where do I get the scheme? Yes, madam, where is the
Yes,
scheme?
Lordship, I'll take the note. Lordship, it starts on page number 127, Lordship.
What is required to objective, increase awareness amongst adolescent girls on menstrual health to increase access to use of high quality to ensure disposal of so and procurement decentralized framework to be done, payment for transportation by ASA from payment of. Who is to make the payment? Yes, central government, are they implementing? You don't know. Have they filed an affidavit? Okay, Mr. Yamavati. Okay, where is the affidavit filed? Has the central government filed any affidavit?
Lordship, yes.
Huh?
They
Where is
filed
that
it.
affidavit? Affidavit, response number, central government is response number?
Last response. 6.
Response number 5,
6.
Lordship, for the effective implementation of the scheme, the school education department need to be a party in this case. Because they're also implementing the scheme.
You want to enlarge the scope of this act?
No, Lordship, we are doing our part, Lordship.
Therefore, let us look into this.
Lord. And in my affidavit,
Where is the affidavit of the response central government? Who is the central government is response number? I sent. 1, 2, and 3. It's on number 6.
Respondent number 6, Lordship.
Yes. What do they say, Mr. Mujoy?
Lordship, in fact,
Are they saying that it is implemented or not?
it should be implemented, and they're also saying that the funds have been released for that.
Lordship, I have not received any affidavit from them.
I have also not received here.
It's only 5 page. I mean, the contents is 5 page. Annexures are there, Lordship.
But there's no affidavit. We have no affidavit. Huh?
I don't have an affidavit.
I also don't have the affidavit.
Lordship,
Okay, what is your stand? Let us see. You are 1, 2, and 3.
Yes, Lordship.
Now, what have you done?
Lordship, may kindly come to my affidavit.
Which one?
5th on the month of May 2025. As per the direction of this court, court directed us to file an affidavit.
13.5.
Yes.
Additional affidavit.
No, Lordship, the latest one.
That is filed by 2000.
In the month of May 2025.
That is a affidavit filed by respondent number 1, 2, and 3.
Lordship.
On 13th May. Okay. Then?
Yes. Lordship, may kindly come to the scheme. I've explained in paragraph 3, Lordship. So this is our explanation with regard to the scheme, Lordship.
In 3 districts of Khifri, Nolak, and Iman compiled here as such.
So what needs to be taken out, Lordship?
But as regards these sanitary napkins and all, are you not getting it from the government, central government, or how?
No.
You are purchasing?
We are purchasing.
And that amount which is the remaining amount of the price,
Yes,
that you get it from the central government,
yes,
get a reimbursement.
yes. Now,
Then why you are only having it on a pilot for this?
no, as of now, we have started with 3 districts.
Why?
Lordship, school education is also doing that. This scheme. Lordship, I have made a mention in paragraph 4, page 4, Lordship. Because they are also a part of the scheme, the department, school education department. Now, apparently, the school education department is not a party in this case. They have rather made the science and technology. What has science and technology got to do with?
Mr. Mujo, you have to understand this is a PIL.
Yes, Lordship.
Don't go into technicalities. We'll have the school education department.
Yes, Lordship.
Okay, the question is here. So this scheme
Lordship.
is being presently looked after by, is also implemented not only by the health department, but also by the school education.
Yes.
So to get a better understanding
Yes.
as to whether it is only effective for 3 of the districts or is it
Yes.
pan Nagaland,
Lordship.
we can get it done, we can know only when the school education department is a party,
Yes.
because they are also supplying this at subsidized rates, the sanitary napkins and giving education in that regard.
Yes. And from our side, we train 2 teachers from every school on this awareness.
But why are you still stuck with only 3 districts? We have how many?
No, Lordship,
eight
not
districts.
only these 3 districts, Lordship. In the next PIL, Lordship, the next.
You are appealing for whom? School education.
No, Lordship.
You
I'm
can
pleaded
appear
as
for-
respondent number 4, the Nagaland State Social Welfare Board.
Okay.
Earlier, when the petition was filed, the board was functioning. However, now at the present juncture, the board is already defunct, Lordship. I have made my submission that the board is not at all the implementing agency, and therefore my name may be deleted, Lordship. I have made my submission already. So I've got nothing to do with the scheme actually.
So we can take your services for appearing for the school education?
No, Lordship, no,
You are
Lordship.
not a government council now.
No, Lordship. I'm just standing counsel for the board, Lordship. So my humble submission.
For a
may be-
defunct board.
The Nagaland State Social Welfare is defunct, Lordship.
So for that you are a standing council.
No, earlier it was there still, Lordship, so I have to make my submission.
So-
It comes under the ambit of the Department of Social Welfare, Lordship.
Okay, now you are appealing for, you are only appealing for the board,
Board only, Lordship.
not for the social welfare department.
No, this Social Welfare Department is not implemented here in this PIO. Otherwise, so did understanding.
I think you need to do something, Madam Kosa. I think why you are not including the school education department, the social welfare department? These are the
Lordship.
departments which have to look into these schemes.
Lordship, yes. Lordship, I can file appropriate application for implement. But allow me to kindly apprise this court, Lordship. When this PIO was moved, Lordship, when the PIO was moved,
A social
Lordship-
welfare department is a party, response number 7.
yes, Lordship. In fact, they are implemented, Lordship. We were informed the Social Welfare Department was implementing. Then again, also informed the Science and Technology is also implementing.
It's for.
No, Lordship. Allow me to apprise this court. Initially, when this petition was filed,
Who is
Lordship,
appearing for social welfare department?
Lordship 4 and 7, I'm appearing, Lordship.
7.
Lordship.
Oh, 7 is social welfare department.
Lordship, but the scheme has never been implemented in the department, Lordship. We are not a non-department, Lordship.
So you are not,
As far as the RKA scheme
you are
is
not doing
concerned.
anything.
No, Lordship.
So it is being done by the school education.
Medical and school education. Now they cannot wash their hands because this scheme is working in convergence, Lordship. It's there in affidavit also, Lordship. Because here Angawadi workers comes, Lordship. The role of Angawadi workers also comes, who are again supposed to catch a service, Lordship, along with ASHA workers, Lordship. Now if they're saying that, because allow me, Lordship, during the time this petition was filed, Lordship, as per the guideline, it is very clear it's a health department. But again, the information was given that science and technology is also involved. Then social welfare is also involved, Lordship. And because that the scheme was never implemented, Lordship, prior to the filing this petition, Lordship, on 28th February 2024, Lordship, this court has taken note of the affidavit filed by the central government as well, Lordship. In fact, a direction to that effect was issued, Lordship,
Where is that 20?
28th February 2024, Lordship.
Oh, yeah.
Lordship, in fact, it is your order, Lordship.
Now they have gone to 3.
Yes, from 1 to 3, Lordship.
In fact, when the matter was lifted before this court has directed here to file it. Takes note of the affidavit filed by the Ministry of Health and Family Welfare Union of India on 7/12/2023. Yes, I think it must have been filed in the other case.
Yes, it is. We file in the next case, not in the present case, which Lordship is.
Anyway, both the matters are taken up.
Analogous, Lordship.
Yes, this is the case where it is saying, first order, central releases are governed by so and so. Release under the National Health Mission. So the money is being given only to the National Health Mission as per the central government.
Lordship, yes.
Then why you are bringing the school education department? How do you show, Mr. Mujahid, that the school education department have in any manner been involved in the scheme? It may be some other thing they must be doing, but how do you say? But how can you keep on? How
Lordship,
many districts we are having in Nagaland?
Yes, sir.
Lordship.
How many districts we are having in Nagaland?
Now it's 17, Lordship.
17?
Expanded to 17.
17 districts.
17?
Yes.
We are lagging far behind. Only 3 has been done.
Lordship, around 5 are newly created districts, which are yet to have even a district hospital.
Okay, we minus this 5. We have 12. What are you doing? Can't we have a pilot? Tell me whether there is a concept out there for pilot. What is a pilot project? Means we test and try.
Lordship.
First try it and then test it. Try, test. This is it. But where is the concept of a pilot project?
Lordship,
you have to implement everybody.
Yes. In my affidavit, in the second case, I have already set up adolescent-friendly health clinics.
One, two, three, 4.
Yes.
Yes.
At page 4, Lordship. It's not that we are not doing, Lordship.
Then
Lordship,
what you are saying about
page 4 of the affidavit.
then why are you saying that it is implemented in pilot basis?
No, Lordship, putting onto it 3. But as far as other districts are concerned, there are already trained people there.
But are you providing those subsidies?
Yes, Lordship, we are giving.
Where is your statement to the effect that you are giving?
No, Lordship, in here in this affidavit, we have explained, we have already trained people. There's already adolescent-friendly health clinic in 12 districts.
Now, all are understood, Mr. Modi, but the question I'm asking you is very
No, this
specific.
is, Lordship, as far as the 3 pilot districts are
You
concerned.
see, the scheme does not provide any pilot project.
No.
Undertaking
But
a pilot project. No, it does not provide.
No.
Initially, you started with Khifri,
Lordship.
And thereupon you have extended to another 2 by
Yes.
this new affidavit which you
Yes.
have been filed. But what is required as per the scheme, you don't need a department or anything to that effect. You have to provide these. So if you are already having various other, just for example, those adolescent clinics,
Yes.
why through them it cannot be implemented? That's the question.
Lordship.
And if you are implementing, the matter ends there.
Yeah.
So give the affidavit to that effect that you are implementing through them. Matter ends. And we don't further harass Miss Santam on this, putting her
No,
out there
Lordship.
for response number 3 and 7.
PIL number 15 of 19 was initially filed, and we have filed our affidavit.
Yes, that is what I am
Yes.
looking into.
Now, subsequently, another PIL was filed on the same subject matter again. The two.
Lordship, kindly allow me to apprise this court because I think the council is confusing this court. Now, Lordship, this
Let us, madam, we have to only look into one thing.
Lordship,
Whether the scheme which is that of the central government, obviously the central government cannot implement it. It has to be implemented by the state.
State no law.
And the
Lordship.
state will implement and take the money from the center.
Lordship, yes.
That's it. The concept of pilot or no pilot does not arise. But
Exactly.
the question is whether they have the resources through those persons, through their various departments. You don't need a department for that. You can do it by anything. Like just for example, the adolescent clinics. You can do it.
Lordship.
So this is how, but whether this aspect is being brought to the notice of the people. This is how we implement it.
Yes.
Like we have these NALSA, these programs which we have.
Yes.
What is being done out there? They say out here that look here, this is the department, they are going to giving all these things. I still remember you, Mr. Moji, you were showing me there in that Kohima program that these are the things which we are doing. So this is an information that you are implementing. Have you been informing the people concerned? That's it.
Lordship.
And so that they can avail the benefit of getting subsidized sanitary napkins. They are given due knowledge how to dispose it. They are given things or basic ideas as regards the menstrual health. That's it.
Yes. Now, Lordship, in my affidavit, in the first PIL, I have already given a statement. Lordship, may kindly come to page 3, the activities that we have taken up, Lordship, in the other PIL.
Additional one,
PIL number 15 of 2019.
which is going on from 2019. It cannot go like this.
No, Lordship. No, Lordship.
2019 a PL going on.
No, Lordship, this affidavit was filed in the year 2021. And the activity is still going on, Lordship. It's not that it stopped. Lordship, may kindly come to page.
No, Mr. Muje, this affidavit filed in 2021.
Yes.
Okay. We would. Mr. Muje, why don't you file an affidavit bringing on record? Because what has happened in 2021, 2022, 23, we have gone another 4 years down the line.
Yes, yes, Lordship.
So now what is the present status?
Lordship, yes, I can do that.
One present status.
Yes.
How are you implementing? The implementation does not require that you have to go, you have to, are those adolescent clinics which you have mentioned in that affidavit?
It's functioning.
No, you trained out those persons.
Yes, Lordship.
And are they available?
Yes.
The third is, have you informed people that you can get it there?
In 2021, we have stated that we have covered 17,262 students across the state in 2021.
Why should we go into how many students are there? We are concerned as to whether there has been due implementation. And implementation of a scheme of the government can happen when you have proper publicity.
Yes.
And have you been giving a publicity to the people of all concern?
Yes.
That in these adolescent clinics, you can get your idea or the scheme implemented or these benefits you are going to get it.
Yes.
That we are going to get it. So these are, bring these on affidavit as to what you have done.
Yes.
In 2021, this was filed. They have never refuted any of our statement. Lordship, yes, I understand.
Mr. Mujoy, we will close these two PLs if you file an undertake affidavit to that effect, and we are
Yes.
satisfied
Yes, I'll do
that
that.
you are doing it.
Yes, I'll
That's
do.
all.
Yes, I'll do.
Doesn't require much.
Yes.
But the thing is, initially, there's no denial of the fact that initially you did not start.
Yes.
The ignition key was put by Madam by filing the PL. And because of this, now you are doing it. But whether there has been proper publicity for people to know, that's it. You see, these schemes? These are for the people who are needy, not for those who are doing well. They can very well get it everywhere. But for the people who are needy, these schemes are there. So are these needy people being informed that these are schemes which are available and kindly avail your benefits from these places? It requires this affidavit. We have heard Ms. So-and-so, the learned counsel, appearing on behalf of the petitioner.
Lordship, also, I'm sorry, my apology for interfering. PIL 15 of 2019 was filed, Lordship, for enhancing the number of adolescent health-friendly clinics, Lordship. Because this play a very crucial role, Lordship.
Understood.
Lordship.
Let them file it.
Mm.
Once they file it, then you come up that the inadequacy aspect you bring it
Lordship.
later on.
Then-
So they are bringing an affidavit. They are filing a detail only in the year 2021 or 23.
Exactly, Lordship.
So now let them file it, what benefits they are doing it. Thereupon you take it up as to
Lordship.
whether it is inadequate. It is not the question of clinics, how many are there or not. The question is whether these facilities are available.
Lordship.
It may be in any place, but the people have to know where these facilities are available.
Lordship, that in that case, please, Lordship, let them also give a figure of how many adolescent health center clinics are functioning, Lordship.
That they will be.
Lordship, at the time of filing the PI, Lordship, as per the information obtained through RTI, there were only 36 clinics functioning, Lordship. This is also not consonant with the guideline, Lordship. So this is we are talking about the future of the people, Lordship. Our adolescent disease are confronted with so many issues, mental health issues. No, this is why the scheme is looking at, RBSC scheme is looking at, Lordship.
Tell me one thing.
Lordship.
How many adolescent clinics are working have been mentioned in the affidavit.
Lordship, that was, yes.
You as a PI, have you informed the people also to whom you know that spread this knowledge, that you can get your benefits in all these places?
Yes, Lordship.
Has the PI petition
In fact,
done
I'm in
that?
touch with the people, Lordship. They're saying it's very less because it's
Madam,
not-
the thing is, you have come before this court when there was nothing done. Now things have improved.
somehow,
Now,
Lordship.
yes.
I agree.
We give due credit to the petitioner for bringing it. There's improved. But the question is now is whether this improvement, we require further improvement and whether they are doing the work or not.
Lordship.
So let's pass the order and we'll see on the next date.
Okay, Lordship.
Okay.
All right.
We've heard Ms. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. N. Mujoy appears on behalf of the National Health Mission. And Ms. A. Santam, who appears on behalf of the respondent 3, 4 and 7. 4 and 7 in PL number 23/2020. Full stop. The issue involved in this present in both the PLs is regards the implementation of the Rashtriya RKHK scheme, bracket menstrual hygiene scheme. Full stop. These PLs have been filed in the year 2019 and 2020, alleging non-implementation of those schemes announced by the government of central government. We have also taken note of that in terms with the said scheme, the state has to provide sanitary napkins to the needy, sanitary napkins at subsidized rates, and further provide due education on the menstrual health. Though the state have stated in the affidavits that the scheme have been run in 3 districts as pilots, in pilot projects. But at the same breath, Mr. N. Mujoy, appearing on behalf of the NHM, submits that the scheme have also been implemented in all the districts through the adolescent healthcare clinics. This court have further inquired as to whether we take note of that for the purpose of proper implementation of a scheme, there is a requirement of publicity of the scheme and the benefits thereof, so that the persons who are entitled to avail the scheme can approach the authorities in that regard. We inquired with Mr. N. Mujoy, the learned counsel appearing on behalf of the NHM.
Standing counsel. Standing counsel.
Okay, standing counsel appearing on behalf of the NHM, as to whether such implementation is being carried out by providing due publicity in all the districts of the state of Nagaland. And as to how, and to provide an up-to-date status. We are also of the opinion that through adolescent clinics, health clinics also, the scheme can be implemented. And as such, accordingly, we direct the National Health Mission, who are entrusted for the purpose of implementation of the scheme, to profile an affidavit as regards the present status of implementation of the scheme. And further, as to how many adolescent clinics now are presently functioning wherein the scheme is being implemented. List this matter again on, list these matters again on 8th of October.
Lordship.
Also, because I have to get the information from all the districts.
Okay, 15
October. Obligation.
Mr. Murthy, we can close it if you are doing it.
Yes,
Yes.
Lordship.
We can close it because you are, it is not that you are not doing it, you are doing it, but it's the question as to whether there has been due publicity. Huh? We can strike out the names of the social welfare.
Lordship, yes.
Let her not be further troubled. Miss A. Santam. Miss A. Santam, the council who represents the respondent number 4 and 7 submits that the respondent number 4 is no longer in existence. And respondent number 7 has nothing to do as regards the scheme, in as much as they are not the department who is implementing the scheme. She therefore submits that the name of the respondent number 4 and 7 be struck off in PL number 23/2020. Ms. So-and-so, appearing on behalf of the petitioner in PL number 23/2020, had no objection to the striking out of the respondent number 4 and 7, taking into account that they have no role to play in the implementation of the said scheme. Madam, you just put the name of the scheme, somewhere. Accordingly, this court, we strike out the names of the respondent number 4 and 7 in PIL number 23/2020. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties in PIL number 23/2020. And the registry, before the registry within 4 days from today. And the registry shall, on the basis of the said memo of parties, make necessary correction in the cause title and update the same in the CIS.
Lordship.
By Monday, you filed it?
Yes,
By
Lordship.
Monday, huh? Next Monday.
That's the-
That's right for some time.
For admission, item number 7.
Yes, what is this?
Come to the blood banks, Lordship. Blood bank. Setting up a blood bank in the district hospitals.
You're doing it?
We have, Lordship, we have already set up in other.
In all the district hospitals?
No, Lordship, because there's a guideline. There has to be a consumption of not less than 2,000 units in a year by one blood bank. Unless you have that mandatory requirement, the licensing authority does not issue license to us. Though we have a blood bank, we cannot have a license, and we cannot run the blood bank without the license. And that is done by the Central Licensing Agency.
No, but why were the PI files?
To set up blood bank in all the district hospitals.
So you are not in a position.
And also, blood separating component lordship.
But how are people going to do? Means
No,
how-
Lordship, we have.
See, this regulation of 2,000 units
Lordship,
is made where? Made by whom?
Government of India.
So has the government of India taken into consideration that the population out here may be less.
Lordship.
The difficulty from one district to the other going would also be very difficult. Has the
Lordship.
government of India taken into account that?
Now, Lordship, we got to the status of the blood bank and the blood storage unit. We have given in our affidavit. Lordship, in against this affidavit, they have filed an affidavit in reply again.
Yes, Lordship, as directed by this court, Lordship. Yes.
So now your thing is, what do you want to issue a direction for setting up blood bank in Erin, Kifri, Longlang? Yeah. So in the only you are having blood banks in these three districts. No?
Yes, yes, we have.
You are having in Ferren, Kifri, and Longlang.
Wait, Lordship. Lordship, may I come to page 2 of my affidavit, last affidavit that was filed on
I'll be respondent number.
respondent number 1, 2, 3, and 4.
And one affidavit has been filed by the central
On
government.
4th of February 2025.
What does the central government see?
4th of February.
But there is another problem. I think maintaining the blood is also a problem. No?
Exactly, Lord. We have supposed we keep 2,000 units. If it's not used, because there's a lifespan for the blood also.
It is another big issue.
One standard for the entire country.
Yes.
This additional affidavit filed on 11th or 12th of November 2024.
No, 4th of February 2025. 4th of February 2025.
Sorry.
Yes, Lord.
This 10th of February. Yeah.
Yes, it was signed on 4th, but followed that, yes. Now, Lordship, may I kindly come to my affidavit at page 2, paragraph 3, the status of the blood bank and the. Now it's called blood centers, not blood bank. Lordship. It has been redesignated. Lordship, I may be allowed to read the paragraph 3, Lordship. That with regard to the direction of this Honorable Court, answering Ibono beg to state that besides the newly set up blood bank at Ringsang, Kifri, Mon, and Pak. Yes, we have in Kifri, Mon, and Pak. The other existing blood centers, they call it bank before, are at Naga Hospital Authority Kohima, Dimapur District Hospital, Dimapur, Dr. Inkong Lipa Memorial District Hospital, Mawjun, Christian Institute of Health Science and Research, Dimapur, 154 Army General Hospital, Jakama, Kohima, and 165 Army Hospital, Rangapahar, Dimapur.
Kindly come to paragraph 5.
Lordship, paragraph 5. Yes, Lordship. That beside the above mandatory requirement, the Government of India has issued guidelines for in-health units whose annual blood unit consumption is less than 2,000 unit. Blood storage centers certificate is issued after existing MOU and consent from the licensed mother bank blood center. This center should be under the supervision of the medical officer and laboratory technician who has undergone 3 days of training from recognized blood center on safe blood handling and after fulfillment of the condition mentioned in provision of the drug rules 1945. So there's a specific conditions under the drug
But
rules.
the fact that if it is less than 2,000 units also,
yes,
it can be done.
So if it's less than, then blood storage centers, not blood center.
Maybe, but this can be done.
Yes. If unit is less, then we can have blood storage centers. But that should be meant by a licensed, consent from the licensed mother bank blood.
So you may have to, just for example, if you are having in Pain,
yes,
the nearby district doesn't have it.
Yes.
So that from that is the mother one.
Yes, that's the mother. Now, besides that, Lordship, now.
So it is not the question that 2,000 is required.
Yes. Now, Lordship, coming to the manpower requirement. There's a specific qualification to be posted in the blood banks.
We are not concerned with the blood bank. You also will look into what is required in the blood storage center. Your basic question is, these areas, there is no consumption of 2,000 units.
Not sure.
So we cannot. That is what you are submitting. But the question is, if it is less than 2,000
Yes,
units,
yes.
you can have blood storage center and issued after executing MOU. These centers should be under the supervision of a medical officer and laboratory practitioner who has undergone 3 days training for recognized here. So you require these two.
Yes.
You may not require so many blood.
Hmm.
But
No.
you require limited also.
Yes.
Yes.
By a medical officer. Now, the requirement of a medical officer, the qualification. Lordship, may I come to paragraph 4 at page 3. Under the drug rules 1945, manpower requirement. Under rule 122G of the drugs and hospital rules 1945 provide for qualification of medical officer to be competent technical authority for blood center. Degree in
Mr. Mujit, are you telling me that after 75 years or so, well, now we are nearby 80. 80 years of independence, the government or the union cannot afford to have a medical center or blood center for those persons who may be in need of blood? You are having hospitals, payment of made for making hospitals, everything. But at the end of the day, a person would not have to go a long distance of around 100 kilometers in road conditions, which are also pathetic on account of your other client. So,
Blood can be needed urgently also.
how do you expect that you will have buildings, huge building, but a person who needs blood has to travel for 100 kilometers?
Now, Lordship, the blood centers and the blood storage unit has been set up in strategic areas for accessibility, Lordship. For accessibility.
No, are you therefore meeting the square feet, square area, square kilometer area? Are you meeting it with your present blood centers, blood
Yes,
banks?
Lordship, that's why I was showing the blood centers as well as the blood storage units. So we have,
do you have blood storage units? Where?
Lordship, can we come to paragraph 3?
No, you don't say me how many blood center units are you? There's no mention out here. These are blood centers. Other existing blood center banks are at Naga Hospital, Dimapur, Imphal, Dimapur, Kohima, Dimapur. Existing blood storage centers at Ferin, Tumukidama, Mon, Wakka, Kipri, Junebeto. What about the other places? You are having so many out here in Dimapur. You are having so many in Kohima. But you don't think the people out there have also a right to leave?
So for the eastern area, 3 districts were given. Tuingsang, Kifri, Mon.
Where?
Lordship, may I come to paragraph 3? Yes.
Newly set up blood banks at Twinsang, Kifri, Mon, and Pek.
Yes.
Pek is nearby.
No, Lordship, it's
Ferin is there nearby.
Lordship.
Ferin is nearby.
Perin.
Huh?
Yes, it's not very far from here.
Ferin is nearby.
No, Peren, it cannot be said it's near the road. If you see the road, aerial distance may be short, but if you see the road.
Takes a lot of time.
Yes.
Okay, now tell me, that is why I asked you. Nearby, how will a person in Ferin get the benefit?
Now they have this thing. Peren.
They will have
They
to
have,
come to,
yes,
they will have to
station.
come to Kohima.
No, in PHC, CHC, Community Health Center, Jaluki, they have the blood storage unit.
Where?
The subparagraph A, CHC Jaluki parent. So under parent, yes.
So they have it. But what about the other places? The thing is, every person has a right to access of a blood center, blood bank, in whatever name you call it.
Yes. Now,
The state is, it is the question of manpower, it is for the state to do so.
Yes. No, we don't
And
have
if it is the case,
specialists.
and if you want us to pass an order, I can help you out.
Lordship.
For the purpose of the manpower, for that. But the
We-
question
we-
is,
Lordship-
you have to have within a particular accessible distance. And if you have it, well and fine, we cannot be the executing authority and look into it. But are you satisfied from yourself that in the entire state of Nagaland, there are blood centers or blood storage centers, whatever name you are called, which can be accessed by the people of Nagaland? That's it.
Lordship, on that context, if I may-
Mr. Muzir, don't think about your client, but think about
No, no, no.
yourself and tell me.
I'm talking.
Are you satisfied with the setting up of the blood centers or blood storage centers that the people in Nagaland would have access to?
No, Lordship, I'm not against that, Lordship. I'm not refuting that. But Lordship,
So therefore, these are not adversarial litigations. So you suggest what is required to be done.
we don't have the
If
men.
it was a
we
writ
don't have
appeal,
the manpower.
Mr.
We don't have the
Mr. Mojo, if it was a writ appeal, I would have heard you on all these things, justification. But the question is, we are in a PI. Are you satisfied by yourself that there are adequate numbers of blood banks or blood centers which people will have access? And if not, what is required to be done is what a lawyer.
So, Lordship, I am not against that. There should not be blood bank or blood storage unit in each and new corner accessible by the people, Lordship. But the main concern here is we don't have the requisite manpower.
So therefore, it is a constitutional duty of the state. Mr. Mojo, don't think about that. When it is a constitutional duty of the state, are you tomorrow going
No,
to stay?
Lordship, when I say-
I'm saying that, the state of Nagaland or the Union of India doesn't have the money out here, so road we don't make it.
No,
And let the
Lordship,
people
it's not
go.
a question of
No, say that.
we don't have qualified people to employ.
You don't have the people means the people have to be employed. The state has to employ.
No, Lordship.
Wait,
right.
there's no, and if the state does not have, the state has to take granting aid from the government of.
No, Lordship, it's not a question of payment. Where I'm saying
That
there's
it
no
is
qualified
required. No, I'm not-
specialists.
No, Mr. Mojo, I'm not saying, you're not saying out here that as regards it is required. But if you think that it is required, then the question is, the states not having problem or resources to have the manpower.
No, it's not a question of resources. Lordship. It's not a question of resources. What I'm saying is that we don't have the specialists from the state.
You have to get some from somebody or train them. You need, what do you require? A person, medical officer who has passed the MBBS.
Lordship.
Secondly, he has to have certain experience in a blood center.
Diploma in pathology.
Huh?
Pathology.
Whatever may be. He has to have some experience at the blood center. And thirdly, you have to have those technician. Technician is not required for that. You only need that for medical officer. So you have to train them, send them. You don't have it. What happened to the Nagaland Medical College? Has it started?
It started there, Lordship. So in due course of time, we'll have enough doctors.
Look, can you say that till then nothing happens? Well, Nagaland let the people die without the blood.
Stop.
Can you say that?
Lordship, is there any instances where a patient did not get blood and he died, Lordship? It's not that. Every possible means has been taken, steps have been taken that any patient that requires.
So give an undertaking that whenever a patient is in need of air, the state will provide that blood.
We are providing.
Now you provide that. Well, and if we give an undertaking, matter over, we close it. Taking into account that there are, as per the state, there are adequate blood bank or blood center, and the state is in a position to provide that whenever there is a need. So there is no requirement. Put it on affidavit.
Lordship, if a short time may be given, I can get instruction and I can file an affidavit.
You file that affidavit.
Lordship.
Once you file it, we can close it.
Yes. That is 2 weeks maybe after Lordship, because
We have heard the learned counsel appearing on behalf of the petitioner and Mr. N. Mujoy, the learned counsel appearing on behalf of the Health Department.
Health Department.
Health Department. The PIL in question, the public interest litigation in question, is in relation to inadequate setting up, in question is seeking appropriate directions for setting up of more blood banks. In the setting up of more blood banks. Where is the petition? More blood banks. And more particularly, in DH, what is DH? District Hospital. In District Hospital Perin, District Hospital Khifre, District Hospital Longling of Nagaland. As well as for further consequential directions. An affidavit an additional affidavit have been filed by respondent numbers 1 to 4.
Lordship, if I may allow to address one issue. A reply has been filed to my affidavit by a different person. The petitioner is a different person.
I'm not on that. I'm only dealing with your thing.
That is petitioner number 2, Lord. Petitioner number 2 is filed. There are 2 petitioners in this case.
Been filed by the respondent numbers 1 to 4. Wherein it has been stated that besides the newly set up blood bank at Twensang, Khifre, Mon and Pek, the other existing blood center, bracket bank, are at number 1, Naga Hospital Authority, Kohima, B, Dimapur District Hospital, Dimapur, C, Dr. Imkong Liba Memorial District Hospital, Mokokchung, D, Christian Institute of Health Science and Research, Dimapur, E, 154 Army General Hospital, Jakhama, Kohima, and F, 165 Army Hospital, Rangapahar, Dimapur. It has been further mentioned that existing blood storage centers are at A, CHC, Jaluki, Ferel, B, CHC, Mezifema, Sumikidema, C, District Hospital, Mon, D, District Hospital, Woka, E, District Hospital, Khifre, and F, Hejuku Memorial District Hospital, Junebato. Further to that, it has also been mentioned that what are the requirements for setting up of a blood center as well as a blood storage center. Upon perusal of the said affidavit, this court inquired with Mr. Mujoy, the learned counsel appearing on behalf of the respondent numbers 1 to 4, as to whether the present setting up of the blood banks of as well as the blood storage centers are adequate so as to meet the requirement of blood to the people of Nagaland when there is a need arises, and whether the people of Nagaland can access those blood banks The learned counsel appearing on behalf of the respondent numbers 1 to 4 submits that he file an affidavit in that regard. List this matter again on 15th of October 2025.
Obliged, Your Lordship.
For admission, item number 8.
Yes, Mr. Jimomi, what
Yes.
is this?
Yes, Your Lordship, so, just briefly, Your Lordship, just 1 minute. So National Highway 129A, National Highway 129A, it was notified, work orders were issued. The executing agency was the NHIDCL. So NHIDCL deviated from the description of the National Highway 129A and a portion which is from Vimla to Mainamsi, that was left out. So I filed the first PIL. PIL number 3 of 2021. Now, during the pendency of PIL 3 of 2021, that portion which was left out was included in National Highway 329A. And by judgment and order dated 17/11/2021, the direction was given to construct this highway within a period of 3 years. Not been done. That's why I'm here for a second time, Your Lordship.
3 years.
3 years.
Highway.
Yes, Your Lordship. The direction was
What is the distance?
about 45 kilometers. 45 kilometers. And this is the road which
I think
everyone takes, Your Lordship. When National Highway
Mr. Jimomi, I think we should close this PL.
Hello.
You file the PL after I retire. I think then the time which is mandated for 45 kilometers will be open. Don't you think, Mr. Singh? But NHIDCL to do work out here in Nagaland in 3 years is too less. Isn't it?
But this work has not been assigned to the NHIDCL, Your Lordship.
To whom?
It has not been assigned. No. It has not been assigned. So the National Highway 329A was declared by the central government under the National Highways Act. But the actual contract has not been assigned yet. A work order has been issued for the preparation of the DPR.
Who has issued the work order?
The MRTH. MRTH.
The MOT is taken by itself.
Yes, Your Lordship. The board itself has assigned the consultancy for preparation for preparing the DPR to one agency. That is ongoing.
So the work has not been, the project report has not been made.
Apparently not, Your Lordship. That I think the
Union
there
is
no one
not
from the
there.
union here presently.
But
But on the last
taking
order,
into account that Mr. Yangavati is not present today and the instructions and
Your Lordship may see the last order. On 28/85.
and the instructions so sought for by the order dated 28/5/2025 cannot be. It is seen that by the order dated 28/2025, this court had directed the respondents to apprise this court as to how much approximate time would be required for completion of the acquisition proceeding for construction of the said national highway, so that a time may be fixed by this court for completion of the construction of the NH 329A. But Mr. Jimomi, how can we fix a time? Well, anyway, Mr. Yangavati is not present when the matter is called. This court further inquired with the state, Ms. Inalu, as to what is the status of the acquisition proceedings. The learned counsel submitted.
Your Lordship, here, the counsel, LT Sandam, additional AG, was appearing in this case, but he's.
If I may, Your Lordship.
He is yet to receive instructions.
On
and-
28/85, I was appearing to BC, so perhaps I cannot make myself very clear what I actually wanted. But first, Your Lordship, the DPR has to be completed. That is still an ongoing process.
But has the acquisition been done?
No, DPR first, Your Lordship, detailed project report.
Detailed project will happen, but that is for the cost. So
For the
DPR
entire
has
project.
not been done.
It has not been done yet.
But
So
the-
that contract
first
has
the
been awarded.
DPR has to be prepared, by the central government.
Yes, ma'am. That is yet to be done.
We inquired with Ms. Sinalo, who appears on behalf of the state respondents in respect to the acquisition proceedings. He submits that the additional Advocate General, Mr. L.T. Samtan, is actually looking into the matter. Mr. A.G. Mummy, however, submitted that even the DPR have not yet been done. And as such, without the DPR, the question of further going for acquisition or for construction, how much time the area construction will take is very difficult to ascertain. Taking into account the above, list this matter again on 22nd of October 2025. In the meantime, both the state respondents as well as the central government shall apprise this court as regards as to whether the DPR has been prepared and is there any requirement of any acquisition process, acquisition of land, and if so, what is the status?
For admission, item numbers 9 to 11.
What is this? Writ appeals?
Yes, ma'am.
What should we do? Hearing?
Yes, ma'am.
Fix it for hearing. There's nothing else. Has it been admitted? No. Huh? No, it has not been admitted. We admit this. What is the direction passed?
Your Lordship,
Where's the judgment?
just after the synopsis.
We are taking up 6.
Yes, ma'am, 6.
What is the judgment passed? Where get the judgment?
The operating portions at page 14.
1-4.
Yes, ma'am. Paragraph 15.
Huh? Are you sure?
Yes, ma'am. Page 14 of the judgment. Page 14 of the judgment. The first, after the synopsis, Your Lordship. After the synopsis. After the synopsis.
Oh, yeah.
Page 14 of the judgment, paragraph 15.
After the synopsis. Okay. What is the case here? Assembly of board, so and so.
Paragraph 15, ma'am.
Communication.
My Lord, we also see the order of the Supreme Court dated 19-2.
This court?
Yes, ma'am. 19-2.
2025,
ma'am. 19-2-25.
No, 19-2. Yes, 19-2. We've heard the case to some extent and would learn it here. Council to satisfy as to whether AGEI is a state within the meaning of Article 12 and writ will lie against the series. On the question of maintainability.
Yes, ma'am.
Who is appearing for this? Assembly of God.
Assemblies of God of East India. It's a religious body, Your Lordship.
But the direction here has been passed to, there is some the involvement of the Deputy Commissioner.
No, my Lord. So the Deputy Commissioner, that is a separate petition filed by us, where the Deputy Commissioner interfered in the functioning of the AGI by an executive order. That is a different one, Your Lordship.
Okay. Anyways, Article 12 question maintainability of the writ petition will be taken up at the time.
Very well, ma'am.
We admit this appeal.
Very well, ma'am.
Full stop. The heard Mr. Ejimumi, the learned counsel, appearing on behalf of the appellant on all the appellants.
Yes, ma'am.
Appearance in all the three writ appeals. Mr. Siti Jamid, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 1 and 2.
Your Lordship, if I may, on 23/10/24, the appeals were admitted. 23/10/24.
23/10/2024.
All the three appeals.
Yes, ma'am.
Then why the matter come up for admission? Yeah.
What's it for hearing, Your Lordship? Not a problem.
This is 6 and 7. What about 14?
Have it back together, Your Lordship, perhaps. All three have it back together.
Okay, but this is 6 and 7. What about 14? Because that order is 23. Hey, there is no order here. Nobody has touched 14 till now. Anyways, heard Mr. Ejimomi, the learned counsel, appearing on behalf of the appellants in all the three appeals, and Mr. Siti Jamil, who appears on learned senior counsel, assisted by so-and-so, who appears on behalf of the respondents. It is seen that writ appeal number 6/2024 and writ appeal number 7/2024 have already been admitted by the learned coordinate bench of this court. However, the writ appeal number 14/2024 is yet to be admitted. So accordingly, taking into account that against the same judgment and order, the other two writ appeals have already been admitted, we admit writ appeal number 14/2024. So list this matter for hearing on 12th of November 2025. Is any interim order? No.
No.
What is this IA for?
IA is for placing additional facts on record after the disposal of the repetition.
Then we allow this.
Very well.
Some order has to be passed.
Very well.
The instant application has been heard, Mr. A. Jimomi, the learned counsel, appearing on behalf of the applicant in IA number 24/2025. Whereby leave has been sought for this court to bring on record certain subsequent events pursuant to filing of the accompanying appeals. Pusto. Taking into account that these are subsequent events pursuant to the judgment, these are subsequent, these are events which have a material bearing on the disposal of the dispute, we grant the leave to the petitioner, applicant, to file an additional affidavit. Within 7 days from today. So liberty is given to the respondents to file any reply if so advised on or before the next date. That is 12th of April, 12th of November 2025. I accordingly stands disposed.
For admission, item number 13.
Let's make a prayer on behalf of my colleague, please, your Lordship. This matter may kindly be listed after a week, your Lordship. He's here to file his counsel.
Please, your Lordship, this matter presents to head this purpose.
Huh?
Yes, in the Lordship on dated 18/6, that is on 15 July. The state respondent has sought for 2 weeks' time. Now it's already been more than 1.5 months.
I was informed that an IA was filed. So on that, he has yet to receive instructions.
My lord,
Madam, you tell me, this case was filed in the month of May 2025. A habeas corpus 2020, May, 3 months have gone. Does it look nice?
Your Lordship, his,
This matter, why was this matter not listed last week? I would have finished it off. We have it next week.
Yes, Your Lordship.
And you have to file, either file or produce the records.
From him.
Heard Mr. So-and-so appearing on behalf of the appellant, the petitioner. And Ms. So-and-so, who appears on behalf of the state respondents, and Mr. So-and-so, who appears on behalf of the central government. The present application has been filed seeking a writ in the nature of habeas corpus, challenging the detention order as well as the confirmation order of the accused, huh?
Yes, Lordship.
Of the
Taking over.
Who is inside?
Your Lordship,
What is the accused name?
Krishna,
No, Tara Chetri. Tara Chetri.
Who is inside?
Lordship. Tara, Lordship, Tara Chatri.
Huh?
Tara Chatri, Lordship.
Wife. Tara Chetri.
Yes, Lordship.
Challenging the detention order as well as the confirmation order, whereby one Tara Chetri, who is the wife,
Mother of the petitioner, Lordship.
mother of the petitioner? No.
Yes.
Mother of the petitioner. Mother of the petitioner. Whereby one Tara Chetri, the mother of the petitioner, have been put under preventive detention in terms of section 3(1) of the PIT NDPS Act 1988. The counsel appearing on behalf of the petitioner submits that the notice was issued by this court on 14/5/2025, and a period of more than 3 months have passed by until date. And the respondents state, have you filed affidavit?
No, Your Lordship.
State have not even cared to file an affidavit.
Your Lordship, here,
And because of the same, there has been a delay in the disposal of the proceedings. The learned counsel submitted that this is a case which requires an urgent disposal, taking into account that it is a case of seeking a writ in the nature of habeas corpus, as have been held by the Supreme Court in various decisions. Today, when the matter is taken up, Mr. V. Jimomi, the learned counsel for the state respondent, is not present. And Ms. So-and-so, who appears on behalf of the state respondent, submits that she doesn't have the file or the records of the case. Considering the above, this court fixes this matter again on 10th of September 2025. The state respondents are directed to file, they are given the liberty to file their response on or before 8th of September 2025 by providing an advance copy to the counsel for the petitioner, and the records be produced on 10th of September 2025 without fail. an attempt shall be made to dispose of the petition on the next date, taking into account the delay in disposal of a petition of a present nature would be against the settled principles of law.
Right, sir.
But next time you just put the trust.
For admission, item number 14.
May I please, Your Lordship?
Same problem.
Why not,
Your case is new, but then also. Habeas corpus 1380 is also not
Lordship,
old.
I
It's
wish
old.
the record is.
We are in the month of September, na? Records are there.
Yes.
What is the ground?
Lordship, whether they are stating regarding like there is no grounds of.
Yes, Mr. Sophie.
Yes, my lord, I'm seeking for revocation of the detention order dated.
What is your ground?
Yes, the ground is that the detaining authority passed the detention order without any subjective satisfaction. There is nothing mentioning the detention order that I'm likely to be released on the honor.
Same thing.
Yes, my lord. There's nothing mentioning the detention order.
We can.
Okay, records there.
Yes, Lordship, I
Not,
received this morning only.
Whether the opposition just stand or waiting.
Huh? No, you be there. We'll record your presence. CAV will give the judgment tomorrow,
Your Lordship.
setting aside all these things.
Paginated, Your Lordship,
The same reason. How many days you are there? Mr. Sophie?
Since 8 April, my lord.
Huh?
8 April 2025.
18?
8
8
April.
April.
28 May 2025. Proposal. When were you arrested?
23/02/2025. 23/02.
23/0.
02.
23. Where you arrested then? 23/2/2025.
Yes, my lord.
Okay, and this you were arrested under NDPS?
Yes, my lord.
Section
21C.
commercial.
Yes, my
Yes, Your
lord.
Lordship. Commercial.
So then what was the necessity, madam, to put him in so and so? He could not get a bail for 180 days. You could have extended under 36(4). You have not done it.
To 1 year.
And 1 year you could have kept it. Anyways, he's inside.
Yes, Your Lordship.
So we set aside this, we pass the order. We'll get the order tomorrow.
Bless the record, Your Lordship.
Mr. A. Sophie, the learned counsel appearing on behalf of the petitioner. Ms. Livika, the learned counsel appears on behalf of the respondent. State and Mr. Jed N. Nuglik, the learned counsel appears on behalf of the respondent number 4. The records have been produced before this court. We have heard the learned counsel's judgment reserved. Pass the order tomorrow.
Yes, my lord.
Next item also same.
For
Next
admission,
item also same FIR.
Same
item
record.
number 50.
Record is different, but it's more or less same.
Where's the other person? Second?
Your lordships.
Yeah.
Lordships, one of the main challenge in this petition is the detainee here is predominantly an Assamese and Hindi speaker. And in his detention order at the time of his arrest, no material documents in the language that he understood was supplied to him. So your lordships may peruse
So what is your
the
ground?
reference.
You are done on the Pitney NDPS.
Yes, your lordship.
So what is your ground, please?
Firstly, first ground is that materials were not supplied in a language that the detainee understood. Secondly, that the criminal provision, there are enough criminal law provisions that can, regular criminal provisions that can take care of his case.
But you have been granted the bail.
I was granted, but then rearrested, Your Lordship. In fact, the trial court found that my arrest was in violation of Bihan Singh's case and released me
No,
forthwith.
not providing you the grounds of arrest.
Yes, Your Lordships.
So you got the bail.
Yes, Your Lordships. But then I was arrested on the 19th.
For under preventive detention.
Yes, Your Lordship.
So therefore, the question is, we have to look into, madam, why don't you file the affidavit? Because he is hesitating on the counts of that it is not understandable.
Yes, Your Lordship.
So I think you need to file an affidavit, and the law he must be relying upon is that judgment of Justice Dhulia.
No, Your Lordship. I'm relying on two judgments. One is Bihan Singh, another is
Bihan Singh is different. Bihan Singh is for the purpose of another aspect. But here we are concerned with the preventive detention.
Yes, Your
Their detention, the grounds of detention have been duly given. The question is, you have not understood the grounds of detention because these have been given in a language which is not being understandable. So therefore, it has to be, therefore I'm saying that judgment of Justice Dhulia, what is name? It starts with A. I forgot the name. So that judgment, you have to look into it.
All right, Your Lordship.
Justice Dhulia and another one is a division bench. And I have also referred to the judgment in one of my judgment in named Herod Singh. Have a look at it. Herod Singh. You have it?
No, I haven't.
So you look into that.
Yes.
And madam, you file an affidavit
Yes,
because
sir.
this is nothing to do with that type of matters.
Yes,
Here, it is a case where that person concerned has asked for violation on the ground that they have not understood all
Yes,
these
Your
things.
Lordship.
And this matter being of 13/8/2025, you cannot delay. You have to file the affidavit by next week.
Lordship can come up next week.
Next week.
Yeah,
Ah.
sometime at the period.
You'll have it next week because you have to file the affidavit. There cannot be a delay.
Definitely.
Full stop. The Miss Livika, the learned counsel appearing on behalf of the state, submits that although she is in possession of the records, but an affidavit is required to be filed on behalf of the detaining authority. Full stop. Supporting the grounds of detention. So the support affidavit has to be filed on behalf of the detaining authority. This court duly takes note of that this is a case of habeas corpus. This is a case where the petitioner have sought for a writ in the nature of habeas corpus, and the notice was issued on 13/8/2025. Already 15 days, 18 days have passed by, but no affidavit has been filed. A final opportunity is given to file the affidavit on or before 10th of September 2025. List the matter accordingly on 10th of September.
Much obliged, Lordship.
Mr. Advocate General, I will take your case as per the, yes, ma'am. I'll take it because if I don't take it, I will take first all the matters and finish it.
Our Pogo, Vincent, Mology. for admission. Item number 16.
Yes, what is your case? Where is the judgment?
Possible find application number 131.
One?
131.
Land ownership.
Now, Mr. Jamil, whether there was any adjudication done under 3B
Lordship,
by the Deputy Commissioner?
no such verification was conducted, Lordship.
Now, if you are claiming on land ownership
Yes,
basis, then isn't it required for the Deputy Commissioner to look into that aspect? Has there been any finding given by the Deputy Commissioner?
No.
Yes, Miss Amy?
Your Lordship, notice may be issued here.
Hmm?
Notice may be issued here.
We admit the appeal or notice we make?
Yes, Your Lordship.
Now, tell me one thing, whether in their family, key persons have been appointed.
Your Lordship, it's just been stated that 3 landowners were appointed. But
That
regarding
is a
the
different aspect from saying whether from their family,
Yes.
the land who have been allotted, whether it is an admitted fact.
Your Lordship, with regard to that, it's no mention has been made, Your Lordship.
Let us
whether
see
it was from their family.
your affidavit.
We'll find page number 61, Lordship. 61.
This is filed by the
State respondents. Lord.
Para 3. What happens in case of multiple landowners?
Now, if after 5th March, there is another one on 16/8. Isn't it?
Yes, your lordship, it's the same one only, your lordship. The content is almost all the same.
But is there anything mentioned anywhere that the three persons who have been appointed were related to the petitioner?
No, your lordship, it's not been mentioned.
Then obviously that aspect has to be looked into. Anyways, we admit the appeal. Now the private respondent is working.
Yes, Lord.
Let him work. We have heard Mr. Muajami, the learned counsel, appearing on behalf of the appellant, and Ms. Amy, who appears on behalf of the respondent numbers 1 to 5. The present appeal is directed against the judgment and order dated 25/7/2025, passed in WPC number 72 oblique 2024, whereby the writ petition was dismissed. Full stop. Taking into account that the materials on record did not show as to whether the member of a family of the petitioner have been appointed on land ownership basis, we admit the appeal. Full stop. The writ petition, the records of the writ petition be tagged along with the instant proceedings. Full stop. We further direct the petitioner to take steps upon to serve extra copies of the writ petition writ appeal upon Ms. Amy, the learned counsel for the respondent numbers 1 to 5. Full stop. The petitioner is further directed to take steps upon the respondent number 6 by way of registered as well as usual. Full stop. List this matter on 10th of November 2025.
For admission, item number 17.
10th. Mr. John, it can be on 10th, it has to be on 12th, huh? 12th of November. Yes, Mr. Jami, such a big brief.
Memphis Lordship. Lordship, the matter relates to regularization of COVID-19 activities. Lordship has disposed connected matter yesterday, Your Lordship, relating to nurse. Here, Your Lordship, the matter relates
This
to
is the judgment of 1/8. Challenging 1/8.
239.
1/8, 2025.
Yes, Your Lordship. That's not good.
But I said out there that this judgment has no effect in that judgment.
No.
Because here I think there are 3 reasons on which the petition was dismissed. First is the reason on the ground that the petitioner had no locus standi.
Lordship.
The second reason is it was a policy decision. So
Lordship.
the question for going for a special recruitment drive
Lordship.
and not through the NPSC
Lordship.
does not have any relevance out there. And because it was found that the decision taken on 1/4/2025 was proper. 1/8/2028, 24.
That is the cabinet memorandum. Approval
And
was
thirdly, you have not challenged the the cabinet decisions of 2020 and 2022.
the basic order, only consequential order has been challenged. But Lordship here, Your Lordship may first examine whether the appellant petitioner have locus standi. Because now, no single judge has, by relying on
Mr. Jamil, don't you think that one ground you can very well take or that have not been taken into consideration by the single judge is that if you look into the 2020 decision which has been taken, 2020 is only for the purpose of creation of additional posts. The creation of additional posts initially 143, then 78.
the first 2020 cabinet memo, Your Lordship, by the 44 posts of a medical officer that was created. And in fact, Your Lordship, I pray that that post should be advertised. I If I challenge the 2020 memorandum, your lordship, that post will not be there.
No, no, kindly look into this office memorandum of 2020.
350. 359.
359. Okay. Yeah, oh no, you see, I'm not concerned. You see kindly here. That is why I'm right. You say 143, I'm saying, nah? I was dealing with the stuff.
Yes, staff.
So here you see this cabinet memorandum. This is a memorandum which is being placed before the cabinet.
Cabinet.
And there it relates to staff nurses 143.
Lordship.
And on the basis of which this was approved on 26/5/2000, 26/6/2025, 2020.
Yes.
And which led to the creation of 143 posts of staff nurse. There is another one whereby another 73 posts were also
Subsequently.
created, 78, which were created for staff nurse. So these 78 posts were also created. And then you have a decision taken on 3/5/2021 by the central government, a recommendation given whereby those people who are working out there, certain incentives have to be given.
Preference.
Huh?
Preference. The word
Preference has to be given to that effect that they will be given some weightage in those marks. Then comes after 3/5/2021, there comes 5/5/2021, whereby not only everybody, there's a direction by the chief secretary stating that the private hospitals also has to cater to keep 50% of the beds, which thereafter comes 22/5/2021. On 22/5/2021, additional incentive has been given that those who do services out there, they will be given certain incentives as regards, they will be for regular appointment, they will be given certain percentage. This written letter, which was written by the chief secretary to the additional, to all the principal director of health government and all this form, was further put a stamp of authority by placing a memorandum on 13/5/2022, which received the approval on 26/5/2022. Whereby the interesting part here is, which I think there appears to be some wrong in the judgment of the learned single judge, is weightage is being given to those persons by giving them 250 marks out of 487.25 marks. Therefore, the fact that the other people are not eligible to contest does not arise.
That is.
But they would be deprived of these 250 marks. Isn't
Lordship.
And this was further, thereupon there is a move where there are certain communications initiated with the respondent authorities amongst that they would like to bring in those COVID appointees who have been done. I don't know what happened thereafter. Then then a notification has been issued. Interestingly, this notification was issued on 2nd of November 2022. And by this notification, they have reduced the post of 319 to 280. And therein, only those COVID appointee posts which have been filled up during the COVID period were brought within the ambit. Thereupon, you see, then also they initiate a process for regularization through the NPSC. NPSC says that we do not want to touch the dirty linen. So we are not going to do anything. You do whatever you feel like. Then comes the cabinet memorandum put on 1/8/2024. When it has been put, that has received the approval
On 6.
Immediately on the 6/8/2024. After getting the approval, then litigation starts in 239.
Your Lordship.
Advertisement was issued.
Yes, the notification 28.
21/7 advertisement was
28.
issued. After 21/7 advertisement was issued, the litigation starts in 239.
Lordship.
With now 239 being dismissed, the government who were all along saying about a special recruitment drive earlier, then special recruitment drive only in favor of the COVID appointees, now has made it by another notification dated 17/8/2025 that we are going only for regularization.
So the SRD is not recruitment.
Mr.
it is-
Tagawasa, am I right?
No, subject, Lordship. I'll respond accordingly, Lordship.
Yes.
Now, they say this is SRD, special recruitment drive. This is not special recruitment drive, it's a misnomer. It is a special regularization drive. Where they want to regularize only those who were appointed during COVID. But preference, your Lordship, that is different, but it should be inclusive. Those who have served during COVID-19, preference can be given. That is different. But I guess we should be also allowed to participate.
Definitely.
Yes.
They will only get a special incentive.
Incentive, Lordship. That is.
Because otherwise it will have a violation of Article 14 and 16.
That is the case.
A concept of regularization is not there. Concept of regularization, if you see the judgment of Uma Devi, there is a concept that there are two fundamental principles which are to be satisfied. First, that these people have been irregularly appointed. Yes, irregularly appointed because there was a examination which was held, but without a written test, but they were appointed, these people. But the second aspect is they have to be at least 10 years. With 2000, they being appointed, I don't know about the others, the nurses being appointed on 15/4/2021. The question of them being considered for regularization in such a short time has a lot of problems. And otherwise, yes, they have but you don't have a right to call for an NPSC. They want to do a special recruitment drive, let them do it, but participation has to be given.
Yes, preference may be given to them at least.
My lord, the issue is this. My lord.
I'm not yet signed that order.
Yes, one of the condition, Lordship. One of the condition to be eligible. What is the locus standi of the petitioners? Lordship, the petitioner responded, petitioner number 1, 11, and 55 were qualified doctors in the year 2020. When people were invited to, when the qualified doctors were invited to serve through an open advertisement, through an open advertisement for contract. He decided not to apply. He decided not to serve humanity during COVID. One. Secondly, Lordship, the remaining petitioners before this in local court were medical students that at that moment of time, when the advertisement was issued after 2020 for temporary appointments. So, Lordship, none of the petitioners had served during COVID. None of them have served even for one day, forget about 100 days. So, Lordship, the first issue which we have raised on the question of mandatability is that when they have not served even for a day, and when 3 of them were qualified, they refused to apply against the advertisement for contract appointment. And the others were mere students. So what right do you have to challenge the SRT? That is one. That was on the issue of mandate. Secondly, Lordship, the second important point is the basic prayer of the writ petitioner is that no SRT, but it should be through NPSC in terms of the service. That is a That was a basic prayer before the legislative report bench. Lordship, the post subject to, and Lordship has just pointed out also, the post was created on 2/11/2022 notification and the cabinet decision of 2020 and 2022, the post was created for SRT, exclusively for SRT. To be appointed through.
How do you say so?
The notification says so.
To me then.
Lordship, yes. If Lordship may kindly allow me to show the notification of 2011 notification.
Because these posts, I'm concerned with the staffers. These posts were created in the year 2020.
Lordship may kindly see 380, page 382, the notification. On the top.
No. These posts were not created then.
Lordship.
No,
Mr.
Takamasa. Mr. Jamil, kindly show me the cabinet memorandum dated 13/5/2022. Where is it?
My lord.
Yes, got it. Kindly come to kindly come to 433.
377.
No, kindly come to 433.
No, Lordship, that is different.
No, that is the question.
My lord.
These are the
431. Lordship, may kindly allow me to read from.
Kindly come to 433 and see the creation order of the posts.
433 connection. Double. Details of the post consequent to special approvals given by the cabinet. Then, my lord.
See the creation orders.
Creation orders. Yes.
It all are 2020.
But Lordship may kindly see the subsequent orders by the body.
No, subsequent order. Posts have been created, Mr. Takamasa, in 2000.
The point is this.
And 173, page 173. 173.
The point I'm making. Post has been created. Lordship, post has been created to be filled up through special recruitment drive.
No. The special recruitment drive came only after 3/5/2021.
Well, kindly allow me to show the Lordship, kindly allow me to show 359.
Yes.
Huh? Lordship, I'm starting from 170, 173.
The 11 is 174. Direction B.
173.
Direction B. Cabinet Further Director.
Yes. This is the second set of 73 posts.
173.
The Takamasa should not have done this matter yesterday before.
Lordship, now witness day. In fact, I have filed it Saturday. I have given advance copies, being their caveator. And on the local lordship, I have two case law citations.
My lord, 174. Lordship, can you allow me to refer to 174? The department should clearly indicate that this appointments, my lord, this is 25/6/2020. The department should clearly indicate that this appointment will be temporary and regular recruitment to be conducted through a special NBSC recruitment drive. So, my lord, 174. Point D. So, my lord, from the creation of 2020 itself, it was through SRT. Post was created for SRT. That is what the cabinet notification says.
Because of that, NPS, if we go by this, then there cannot be an SRD at all. There has to be the involvement of NPSC.
My lord, thereafter, my lord, the point.
I think the best we state We state it's this recruitment process, what has happened. Because this has to be stated. This judgment appears to be not taking into account Article 14.
The matter requires expeditious disposal.
My lord, thereafter, my lord, a notification was issued on 18 June 2025.
Huh?
18 August 2025. In pursuance of the judgment of this honorable court on 1/8. My lord, yesterday it was also shown.
What is that?
Please go on. This is for.
My lord, what I'm saying is the judgment is already complied with. And interview already over. Only result will be declared, interview already done.
But I've set aside that, no?
No, my lord.
I've
No,
set
my lord.
aside all
You
these
have-
things.
you have only- you have-
No, Mr. Counsel, I have set aside all these things.
My lordship is said as the word COVID appointee.
No. I said everything. I've set aside 1/8/2024 where it keeps only for COVID appointees out there. I said this cannot be done because of the fact that it will take away your rights.
Lordship, we kindly appreciate this fact.
And if they have appointed, I have already set
My lord,
aside.
the point I'm making.
I've already set
Lordship-
aside this document.
Lordship, the point I'm
And
making.
that is what I said on 18/8.
Lordship, the point I'm making is that with regard to doctors, the interview was conducted, and in the interview, in spite of the notification of 18, people who had served having 100 days COVID certificate, everyone was allowed to appear for the interview with regard to doctors, not only the COVID appointees. That was the submission I was making yesterday. That in case of doctors, you are allowing all those persons who had served 100 days to allow to allow them to appear for the SRT, whereas for the nurses, it is only COVID appointee. That was what the main submission yesterday. So with regard to
But 13.5 at 1/8 is not for nurses alone. 1/8 is for everybody.
1/8 is
everybody.
for 1/8, my lord, with 1/8 judgment. 1/8 judgment says everyone who served should be allowed to appear.
No, 1/8
Yes.
categorically says only COVID.
Because paragraph 41 of the judgment, yes. In 1/8, paragraph 41 of the judgment, it says 15 contractual appointees who served in the COVID, 83 who were appointed during COVID. All of them, since they have served, you are allowed to appear. That is the judgment of the letter single judge in this judgment impugned.
Which one?
Lordship, you can see the impugned judgment. Lordship, yesterday I was mentioning this. Lordship, paragraph 45.
Yes.
One of the operative paragraphs.
You have SRT, but you cannot take away these people's rights. Now,
Lordship, that is 44, paragraph 44.
No. I think we state this.
Paragraph 44. 515.
Yeah. They will not have a chance. Open recruitment.
Because Lordship in paragraph 44 of the judgment, the learned single judge, people who had served, people who were appointed on COVID, or everyone were allowed to appear. Accordingly, for 90 doctors who were already regular, who appeared for the SRT, 15 of them were contract appointees who had served, and remaining 83 were those who were appointed during COVID. So no distinction was made, and that was the direction of the nursing judge.
Where is it?
Paragraph 44, Lordship. And I was making a submission, Lordship, of the stand of the learned advocate general, additional advocate general on this issue.
Where?
My Lord, 44, 515. In pursuance of the cabinet decision, the government accorded administrative approval to conduct written in Viva voice as one-time dispensation for SRT. The exams were scheduled to be held in such instance. Draft of polling letters has been issued to 98 medical officers who were appointed in pursuance of the advertisement, and also medical officers.
Advertisement dated 4/8/2020. Meaning thereby the COVID has come in. These are all COVID appointees.
Yes.
Then they were not prior to those.
My Lord, you were 15
Mr.
of them-
Takamasa, your
16 of them
no,
were prior to that.
Mr. Takamasa, yes, the case which you were doing yesterday before me, where those COVID appointees were only being allowed to participate.
Yes.
And this is only those COVID appointees, these 98.
No, my Lord.
Yes, it is what appears from
No,
this.
Lordship, kindly allow me to show from the facts. 15 were prior appointees. 15 were already serving on contract. Lordship, kindly allow me to read the judgments to show from the facts. If your Lordship may kindly allow me to read the facts from the first page. Huh? Lordship 492, paragraph 2.
That was not the issue.
Paragraph 16, Lordship, paragraph 16. 16 will clarify, my Lord.
Now, Mr. Takamasa, are you saying this judgment, by this judgment, only those persons who have worked during COVID have been allowed to participate?
Yes. That is,
My Lord,
that is the.
We state.
my Lord, the issue is
And
this.
that is not my case.
The
we
issue is
state-
this.
We state.
My Lord, the issue is
This
this.
can-
First,
No.
First, on the issue of maintainability, whether they are maintainable, whether they have a right to participate in the SRD.
They have a right to participate in the SRD because these people are doctors.
My Lord,
All these are doctors.
but the issue is this.
They may not have
What is
that
the criteria? What is the criteria for SRD? One should have 100 days COVID certificate. None of them have it. None of them have it.
So what? If we go by the office memorandum of 13/5/2022, which have been further notified on 2/11/2022, only weightage of marks of 250 would be given, nothing more than that.
That's,
Which state? Heard Mr. E.B. Jamid, the learned counsel appearing on behalf of the petitioner. And appearing on behalf of the appellants. And Mr. Who appears for the state? Mr. N. Mujoy, who appears on behalf of the respondent numbers 1, 2, and 3. And Mr. Takamasa, the learned
19 to
senior
30,
counsel,
23 and 25 to 101.
appears
Respondent
on
number
behalf
19 to
of
23 and 25 to 101. I have 5 caveat note.
Mr. And Mr. Takamasa, the learned senior counsel, assisted by so and so, who represents the respondent numbers 19
23
to
25 to
23 and 25 to
101.
101. Mr. Jami, you are appealing?
Yes, Lordship, I'm appearing for respondent number 4 to 15. And I have filed a caveat also, Lordship.
Mr. C.T. Jami,
And
the
then,
learned senior counsel, appears on behalf of respondent numbers 4 to 15 and
Lordship, I have filed a caveat, so I may be heard also.
oh yes, I'm just finishing it. 4 to 15 and is there any gap? 16 to 18 is a gap. Who is it?
I'll accept notice on behalf of respondent number 24.
24. Who appears for 16 to 18?
16 to 18.
Who were appearing earlier in these matters?
Muajamin.
Huh?
Muajamin.
Yes, where is Mr. Muazumin? I've seen him. somewhere. These are intra-court appeals. He can appear. And Mr. Muajami, who accepts notice on behalf of the respondent number 16 to 18. Full stop. The present appeal is directed against the common judgment and order dated
1-8.
1/8/2025 passed in WPC number 239/2024 and WPC number 187
Your Lordship, this appeal is directed only against writ petition 239.
No, directed against the common judgment and order passed in WPC number 239/2024 and WPC number 1787/2024. Mr. T.B. Jami, the learned counsel appearing on behalf of the appellant, submits that the challenge made in the present proceedings is only against the dismissal of WPC number 239/2024. Full stop. Take now, Mr. Singh, again.
The present appeal is preferred against the judgment and order dated 1/8/2025, as Lordship has correctly pointed out. Now, the learned single judge, while deciding the case, given the verdict on basically on 2 points. One is on the issue of locus standi, and the other is that in extraordinary situation, the extraordinary decision can be taken. That is a policy decision of the government. Now, it will be very important to consider the time when the entire world was stuck by COVID-19. There were acute shortage of manpower, especially in the health sector. And it is a war against a disease, against a pandemic. So recruitment has to be made. So the government has taken a decision to recruit the health personnel, the medical personnel, to various posts, doctors, nurses, whatnot. And we are concerned with the doctors. Open advertisement was issued. The petitioner number 1, 11, and 55, they were qualified, but they have opted not to come forward because it was a time of between life and death. Now that everything is over, we will take it very lightly. But it was a war. The war room was also open and it was monitored. I will just cite one example. The state government has taken a decision to repatriate all the persons who are residing outside, especially within the country. So for that purpose, few quarantine centers were selected and 2,000 number of beds have to be arranged. Time bomb. 2,000 bed shops were closed. So they had to go to Timapur again to bring 2,000 bed. It's not an easy job. There were no laborers. So department has to mobilize, the government had to mobilize to do all this. And 2,000 bed means 2,000 matrics, 2,000 belows, 2,000 pages bottom. All the requirements. Now, this is a time when many people were afraid even to talk among their family members. Mother has performed duty, she has gone home back, and she is not entering the house. Now, that was the situation. And when the advertisement was issued, 3 persons, although qualified, they have opted not to apply for the post. The other petitioners were not eligible at that point of time because they were in the colleges. They did not possess the MBBS degree. Now, the order was passed and the criteria was 100 days COVID duty. Who has performed, they should be recognized. The present respondent number 4 to 15 are the persons who were appointed during 2012 to 2016. Not the COVID appointees. There are 2 categories, as Lordship has seen. One category is they were appointed during the COVID time. We were the persons who were appointed during 2012 to 2016 and have also performed COVID duty for 100 days. So the post held by us has also been included by the government. Now, during the hearing, we raised the issue of locus standi. You were given opportunity, you have not come forward, and the others were not eligible to hold the post. Now the question is whether the petitioners have performed 100 COVID duty or not. That is the limit. And they have not. Certainly not. Therefore, they do not have the locus standi.
No.
Just one point,
No, one thing, Mr. Javi.
Lordship.
Show me at the time of creation of this post that there was a requirement of 100 days of COVID duty. Show me.
No. That was not mentioned in there.
No, this was done on the basis of a communication issued by the central government on 3/5/2021. See clause 17 of the said document, which says that there would be preferences given.
Yes.
Pursuant thereto, the Chief Secretary writes a letter on 22/5/2021 that you see those persons are given additional incentives who work for 100 days in COVID, that they would be given preferences during regular examination. Then comes 13/5/2022, which then also the basic reason was that they would be given anybody who has done 100 days of work in government or private hospitals, they would be given certain marks on the length of their service in the COVID duty. These 250 marks out of 487 has been mentioned in the notification dated 2/11/2022. Therefore, the basis till then was never, till 2/11/2022, it was never that the others would be thrown out. It became only to be thrown out on 1/8/2024, when by only COVID appointees were given. Then also you were out. Mr. Jamil, you were out there. It is because of you filing a writ petition, you may have some inclusion out here. The order has been passed as regards those persons, including you.
No, Lordship, I'll come under a slight clarification.
No, wait. Now that the question arises, this is the communication. All along, it has been mentioned as a special recruitment drive. Now you see what they have done on 18th of August 2025. You must be having a copy.
Yes.
Forget about all these things have gone for a 6 special recruitment drive. Now they want to do specifically regularization. In the August 2024, when steps were taken, then also it was going on in the manner of a special recruitment drive. Along with it, there were certain tests which were to be given a written examination along with a viva voce. Now everything has been done away by 18th of August 2025, and now they say that it is a simple case of regularization and there will be a departmental screening committee. Now tell me, how on earth do you support it with an Article 14 and 16 being there, which are basic features of the Constitution?
I think we are going little far. Giving in view of the prayer made in the writ petitions, the order was passed. And can you see the prayer in page 43? Page 106.
Yes.
To save time. But all are one sentence, so let me start. In the premises of proceed, it is therefore prayed that your lordship may be pleased to admit this petition, call for the records of the case, and issue rule calling upon the respondents to show as to why a writ in the nature of mandamus and or certiorari should not be issued. And after hearing the parties on the causes being shown, be pleased to make the rule absolute by quashing and setting aside the immune cabinet decision dated 6/8/2024 and immune letter dated 20/8/2024 and direct the respondent authorities to fill up the aforesaid 98 post-staff medical officers as per the provisions prescribed under the rules of 2006. So, no prayer is there with regard to the SRT.
Mr. Zamir, I am not against the SRD. Go ahead. But where is the SRD now? Where is the SRD?
That is pursuant to the order passed by the Honorable Court.
But this is based upon the
This
order.
has been issued.
These
And there is
state
a-
authorities have now been more vilified with this order being passed on 1/8/2025, and now therefore says that in view of this vindication of their stand to go ahead only as regards the COVID appointees, which we were thinking of having a special recruitment drive. Now, as the High Court had put a stamp of authority, we will directly regularize them.
Eligibility for a post under the rule is one thing. And eligibility, in other words, to file a writ petition under Article 226 is another thing.
No, tell me
Now-
Mr. Zamir, whether these people were doctors on that date.
No, they were not.
No, on the date on which 6/8, the office memorandum was issued, cabinet decision, whether they were doctors.
Which decision?
On 6/8/2024, were they doctors?
24, they have already doctor. But in 22, they were not doctors.
Not necessary. As on 6/8/2024, could they have participated in the recruitment process? I think now we.
And they have not performed 100 days COVID duty.
Not necessary. They will not get 250 marks.
Now, by filing the writ appeal, the grounds taken is the petitioners are eligible. And if this process is allowed to continue, their chances for getting appointment in future will be reduced. So, do you want to book a vacancy in advance?
Now, let us stay Let the state fill up through SRD,
Lordship, subject
but
to
giving
repetition.
opportunity to everybody.
Lordship, subject to repetition. The prayer before the legislative bench, because we have amended the prayer. And we subsequent of the resolution petition, we confine to the prayer by respectful submission. What is your prayer? Your prayer is that the post, the SRD to be done away with, and the post of this 19 vacancies to be filled up regularly through Nagaland Public Service Commission. That is the prayer. It was ruled of 2016, only through a regular selection process through the Nagaland Public Service Commission. That is the problem here. So, my lord, if tomorrow, Lordship says that SRD has blocked, that SRD should not be disturbed. But here, the basic prayer is you are challenging the very constitution of the SRD. And that has been rejected by the single bench. Sounds in circle that there will be a SRD. And Lordship.
But what you have done on 6/8/2024 is debarring these people from participation.
The question is this. The question is, what is the prayer of the petition? Because if you have, or if you are agreed that you have a right to participation in terms of 26/8/2024, then there is a totally different subject matter than the further new petition to examine. But for a moment, in this present case, we have to confine to the prayer of the petition. Your prayer is you are challenging the validity of the SRT that is violation of the 2006 rules and all the vacancies created. 98, all the doctors posts have to be strictly filled up through an advertisement in terms of 2006 service rules. That is the subject matter of the people of the single judge. Before the subject authority, we did not put here the prayer. So if, as very pointed out by the if you think that in terms of 2004 notification, 14 notification, that you think that you should be given an opportunity to participate in the SRT, and that you have to, right? The further representation, let them come before this honorable court, you also should be included, but not in this petition, not before this appeal court, because subject matter is different. What is your prayer? It is enough. The challenge the very constitution of the SRC and the ground that it is violation of 2006 rules. And your prayer is that, and the 2024 cabinet decision is challenged. Lordship is saying that you should be included in terms of the cabinet decision of 2024, which they have challenged. They are agreed by that. They are challenging it. That is subject matter, Lordship. So, my lord, whether this honorable court in the appellate stage can go beyond the prayer before a single court, when they are challenging the very constitution of the SRT, how can we say before the appellate court, subject to Lordship, what you say, that they are entitled to be included in this SRT? Because that is never their prayer. We did not give something which they have not prayed for before the single bench, before the honorable court. Also, what is your prayer? Your only prayer.
Mr. Takamasa, if we set aside the cabinet memorandum of 1/8/2024, the entire process by which there is a step for regularization of these persons, as well as for only limiting to those COVID appointees.
Then Lordship, you see, that is not the prayer in this case.
That is the prayer.
No, my lord.
No, the prayer is a 6/8.
Lordship, the question is, the 2022. 2022 remains, which is for SRT. Constitution to conduct SRT, which they have not challenged. And in terms of
No. They are not agree with 22. They don't mind.
Then Lordship.
Mr. Ravi, do you mind 2022? No, they don't mind. They are ready to give up with this 250 marks.
Lordship, if people come in within 2022, then how they are eligible to appear before SRT in terms of 2022?
Because 2022 memorandum only says that we are going to give them additional preferential marks of 250. They are saying that 250 also be on.
The question comes. Then the question comes, in 2022, you were not doctors. In the year 2022, you were not doctors.
So
you were not qualified. So
but you have issued a notification. His cause of action arises. Mr. Takamasa, his cause of action arises. His cause of action arises on 6/8/2024.
But Lordship, it should be prospective. How can the issue whether whether he's entitled.
Are you going to say that the posts were created in 2020 and therefore he was not a doctor, so
Manoj,
nothing doing?
Manoj, the question is whether too many people do.
I think we'll state.
Lordship, only one point, Lordship.
No more.
Can we come to page
No,
287?
no. I've heard you, both of you caveat discharge.
Lordship,
Yes, Mr.
my learned
Muthu.
friend has interrupted
Yes,
me when
Mr.
I was
Muthu,
speaking.
why on earth yesterday you did not appear?
No, Lordship, I've been engaged for this case.
Not that case.
No,
But that is a health and family welfare department. Are you not the standing council?
no, I'm for the national health mission.
Okay, chalo.
Lordship, can we come to page 287?
No, we are staying.
Because in the course of my submission, my learned friend Takamasa has wanted to convey some additional points, Lordship.
Yes.
287.
Ah.
This is a letter by the ministry to
Yes.
all the additional chief secretary.
Come to page 288, clause 17.
Yes. The central government recommends to state union territory government to consider giving preference in regular government appointments of health professionals through the respective public service commission, other recruitment bodies for those health professionals under this special scheme who complete a minimum of 100 days of COVID related duty.
Yes.
So this is one of the requirements, Lordship. And
So
the
therefore,
petitioners-
you have passed an order thereupon that you are going to give them 250 marks. That is the preference.
Now,
Enough.
one of the grounds.
The instant appeal is directed against the judgment, appeal is directed against the judgment and order. Full stop.
Lordship, what?
No,
No,
Mr.
Mr.
Takamasa, I have heard you.
Kiran,
No, Mr. Takamasa.
Kiran, the evidence are in agitation on this issue. Since 29 of this month, they are on agitation for the last 3-4 days. So on the one hand, they are filing this report. On the other hand, they are staging a dharna before the director since 29 of this month.
It will be good.
Last month.
It will be good with a stay. They will not do any more dharna.
Yes. So,
But it is not.
No, Mr. Takamasa, the question is a right to consideration. Right to consideration is a fundamental right. I'm not going to do this.
Well, none of merit. Under agitation, I am only submitting. Certain observation will be given because they should not be allowed to continue the agitation.
I will record. I'll record it and Mr. Jami kindly.
No, your lordship, it is a combined association.
And I hope they would take the lead. Okay.
Lordship, on two
No.
consecutive days in the front page,
Ah.
it is being appeared in the local media. On one hand, they are fighting the case in the court, and at the same time, on one hand, they are going on agitation.
Was there any headline today?
There was.
No,
There was.
today. No, today.
There was.
You said.
No, Mr. Takamasa. Was there any headline today?
Today's paper I have not seen.
No, because of yesterday's order I have passed. Take your seat.
No, one of you was a state, they was a.
I have set aside that communication.
No.
Mr. Takamasa, I have set aside this notification.
Spend on today.
I have set aside this notification of
They was
8th.
ordered that to spend on today. That is the statement given and they are still, let you receive instruction, the government advocate that is there, they are still in this, they are in this fight education. If necessary, lordship, this is the, there was issue notification, press.
Press release.
release,
We have
press
received.
release, they are in this fight education.
It's okay. I'm not going to look into
But
one.
then, certain observation because this is not fact. On the one hand, very soft, on the other hand, in this fight education, on the same subject matter.
Lordship, may kindly appreciate one thing, one aspect. They have made a statement in the petition that they are a bona fide member of NAMSA. The petition, Nagaland Medical Students Association. They have filed a writ petition, the writ petition was dismissed. They can prefer to appeal against an order, Lordship. But rather than preferring an appeal, they have gone on agitation. Threatening, Lordship. Lordship, whether that can be acceptable, Lordship.
How big is the NAMSA?
It involves all the medical students.
How big is it?
Lordship, we don't have the figure with us.
And how
But-
many petitioners are here?
50,
Much bigger than.
So do they have the control over everybody? Somebody may like to go for agitation, some may like to go to the course of the year.
But the subject matter is the same, Lordship.
So how can you help it? If somebody wants to go for an agitation and somebody wants to follow the due process, are you saying that those person will be here? Anyways, let me read the order. The present appeal is this court. Now we have heard the learned counsels. Mr. T.B. Jami, the learned counsel appearing on behalf of the petitioner, appellant, submitted that by the impugned judgment and order dated 1/8/2025, the learned single judge had dismissed the writ petition primarily on 3 grounds. First, that the petitioners did not have the locus standi. The second ground was that the petitioner did not challenge the policy of the state government of the year 2020 and 2022, and as such could not have challenged the office memo, the cabinet decision dated 6/8/2024, as well as the subsequent actions. The third ground for dismissal of the writ petition is that there was that the cabinet decision dated 6/8/2024 is a policy decision of the state. And as such, as the policy decision of the state was not arbitrary or illegal, the question of interference under Article 2 to 6 of the Constitution does not arise. Mr. T.B. Jami, the learned counsel appearing on behalf of the appellant, submitted the 3 grounds on which the writ petition was dismissed with due humility cannot withstand the scrutiny of law. First, he submitted that Article 14 and 16 of the Constitution are basic features of the Constitution. First, the concept of regularization. He submitted that regularization is not a mode of recruitment. And further, by way of regularization, there cannot be a permanence given to the job. The learned counsel submitted that in the year 2020, even before the decision taken to give preferential marks to those healthcare professionals providing engaged in COVID duties, the posts were created. And under such circumstances, the question of going for going for a special recruitment drive in the form which in actuality is a regularization could not have been permitted. He therefore submitted that the petitioners herein the appellants herein are doctors. And as on the date on which the decision was taken, that is on 6/8/2024, the petitioners, the appellants were duly qualified to be considered for appointment to the regular vacancies. The learned counsel further submitted that when the Nagaland
Health-
medical rules,
Health service rules. health.
Now, what is that rule name? Nagaland Medical?
Health Service Rules, Nagaland Health Service Rules, 2006.
The Learned Council submitted that the Nagaland Health Service Rules 2006 are rules made under Article 309 of the Constitution. He therefore submitted that when there is an availability of these rules, the question of carrying out a regularization or by not following the mandate of the rules violates the mandate of Article 14 and 16 of the Constitution. The Learned Council further submitted that the petitioner appellants are aggrieved by the decision so taken on 6/8/2024 and not aggrieved by the decision to give preferential marks to those COVID appointees, to those persons, healthcare workers who have performed 100 days of work. And as such, the question of challenging the cabinet decision of 2020 and 2022 did not arise. On this ground also, the learned single judge failed to appreciate the submissions. The Learned Council, appearing on behalf of the appellant, further submitted that submitted that when the rules of 2006 was holding the field and the appellants duly have rights under Article 14 and 16(1) of the Constitution to have an equal opportunity in participation in all recruitment process subject to eligibility, the decision so taken on 6/8/2024 only to carry out a special recruitment drive in respect to the COVID appointees is in violation to Article 14 and 16(1) of the Constitution, and as such, the said decision was not proper, and as such, the cabinet decision dated 6/8/2024 was required to be interfered with. Mr. T.B. Jamil, the Learned Council further submits that when the Article 3 rules under the Article 309 was holding the field, the state in exercise of powers under Section Article 162 cannot override the same. He further submitted that under no circumstances the cabinet decision dated 6/8/2024 can be said to be a policy decision. The policy decision at best would have been the decision of the state to provide certain weightage to those persons who have, by giving preferential marks to those persons who have performed healthcare activities during the COVID period. He therefore submitted that the learned single judge had misconstrued the provisions of the decision, the cabinet decision dated 6/8/2024 as a policy decision. Per contra, Mr. Takamasa, the learned senior counsel who represents the private respondents, as well as Mr. C.T. Jami, the learned senior counsel who also represents the private respondents, submits that the petitioners herein were not at all eligible as on the date when the decision was given. Decision was taken to carry out a special recruitment drive. The learned counsel further submitted, senior counsels further submitted that on this ground, the learned single judge had rightly held that the petitioner did not have locus standi. The learned senior counsels further submitted that three of the appellants will go, that three of the appellants though were successful in the recruitment which was carried out in the year 2020, but did not join.
He did not apply. Did not
Three have joined.
No, he did not participate.
Did not apply.
So submitted that there were three of the appellants who would have joined, who could have applied post the advertisement issued in the year 2020, but they did not choose to apply. However, the respondents herein have putting their life at peril, have performed COVID duties. And as such, the respondents herein cannot be equated with the petition appellants. And the classifications were carried out by the respondent state in only considering the respondents and thereby not permitting the appellants cannot be said to be in violation of Article 14 of the Constitution. The learned counsels the senior counsels further submitted that this is a case where the further submitted that the petitioners herein, the appellants herein, by way of the writ petition, have sought for by way of the writ petition had sought for, had challenged the cabinet decision as well as the subsequent notification dated 6/8/2024, as well as the subsequent notification dated 28/2024, and have further sought for a mandamus that the recruitment should be done by following by the NPSC. The learned counsel therefore submitted, senior counsels therefore submitted that as it was a policy decision on the part of the state to carry out the special recruitment drive, and there being no challenge to the same, the writ petitioner, the appellants, cannot be permitted to assail the special recruitment drive. Mr. N. Mujoy, the learned counsel appearing on behalf of the Health Department, further submits that the appellants herein are members of Nagaland Medical Students Association, as they have duly admitted in their writ petition as well as in the writ appeal. Pursuant to the judgment and order passed by the learned single judge on 1/8/2025, instead of following the due process of approaching the court, challenging the same, the association to which the appellants belong are resorting to unlawful agitations. Isn't it, Mr. Mojoy? He therefore submitted that the instant appeal on that ground ought to be dismissed, taking into account that they cannot be permitted to take law on the one hand and on the other hand approach this court. We have heard the learned counsels appearing on behalf of the appellants, appearing on behalf of the parties at length on the question of the interim orders, on the question of whether there is a requirement for passing interim directions. It is seen that by way of a separate application, the appellants have sought for suspension of the operation of the judgment and order dated 1/8/2025. Tell me, you have asked for the relief which I can't, giving also has no value.
Now, your
A writ petition being been dismissed, if I suspend, can I suspend a non-dismissal? Tell me, can I suspend a writ petition which is dismissed? What should be your prayer?
No.
Your prayer should have been stay the further recruitment process. What do you have asked for? As writ petition which is dismissed, you ask that judgment to be stayed.
The judgment to be stayed. Your
The moment
Lordship.
I state the judgment, what is the effect?
Now, Lordship, the earlier interim order will continue, Your
No.
Lordship.
How can it be?
Your Lordship.
The
Because
interim order has already merged with the final order. You have a good case, but you have spoiled it by filing a wrong application.
But Your Lordship, in fact, that as read court, this court has and more relief, Your Lordship.
I don't have ins. What have you done?
I pray that my the relief may be molded, Your Lordship. This
How
court.
do I mold it? Tell me.
You
Tell me, how do I mold it?
read in fact, Your Lordship, appeal is a process, it's a continuous proceeding of the writ petition, Your Lordship.
Understood, but the relief which you are seeking for is stay. You are asking that the dead person should be stayed. How do I stay a dead person? I cannot make him to live alive.
Otherwise, Your Lordship, the very purpose of filing this appeal will be, Your Lordship. In the interest of justice, Your Lordship. There is no bar, Your Lordship, for this court to mold the relief.
After that, Lordship, examination is concluded, only result is awaited. It's a fresh course of action. And
Mr. Takamasa, that has no meaning
No.
because I have set aside this.
No, besides this, there's subsequent order.
Mr. Takamasa, why you are not understanding?
No, no.
Yesterday I have
No,
set
no,
aside
no.
this.
There are, my lord, I introduced some other orders where warning letters were issued.
Mr.
And-
Takamasa, why are you not understanding? I have already set aside this notification. When I have set aside this notification, that very appointment goes. Any person, any recruitment process goes for these 280 posts. They cannot go for anything. Then I've set aside this entire thing in my earlier judgment given in the repetition. You should not have. I was only about to state yesterday the process, but you said for dismissal, disposal, I disposed it. And then now you are at peril. This has already been set aside. What to do? Now, after setting aside of these, now if they appoint somebody, and they know what to do.
Even otherwise, in the eye also, Your Lordship, they can mold the relief, Your Lordship, there is no bar.
One should,
Because it's all the same.
my lord, one should confine to the prayer that I have nothing more to say. Because when it is.
File then separately an application seeking stay of the impugned judgment and order dated 1/8/2025 passed in WPC number 239/2024. This court inquired with the learned counsel appearing on behalf of the appellant as to whether a judgment by which a writ petition has been dismissed can be stayed. The learned counsel submits that the intra-court appeal, that this court is sitting in exercising an intra-court appeal jurisdiction. The learned counsel submitted that the intra-court jurisdiction, intra-court jurisdiction, and as such, this court would be at liberty to pass any such order, taking into account there is a further prayer made in the interlocutory application, thereby seeking any other further orders as this court may deem fit. The learned counsel further submitted that in the meantime, a notification has been issued on the basis of the said judgment dated 1/8/2025 on 18th of August 2025, and the process have been initiated for filling up of 280 posts, which is in gross violation to Article 14 and 16(1) of the Constitution. This court, having perused the materials and report, and after hearing the learned counsels, is of the opinion that the submissions so made, that the grounds of appeal which have been urged in the memo of appeal, and the submissions so made by the learned counsel appearing on behalf of the appellant, thereby challenging the grounds on which the WPC number 239 of the 2024 have been dismissed, in the opinion of this court, requires a consideration. Accordingly, this court we also further take note of that in the meantime, by a notification dated 18/8/2025, which have been placed during the course of the hearing, on the basis of the judgment passed by this court on 1/8/2025, which is impugned in the instant proceedings, a process of regularization have been sought to be carried out. Instead of the earlier, a process of regularization have been sought to be carried out in respect to those COVID-19 appointees through departmental screening committee. We are of the opinion that as the judgment dated 1/8/2024, as we would be reconsidering, as we will be looking at, we have already admitted the appeal, the notification dated 18/8/2025, by which a proceeding has been initiated for regularization of the services of COVID-19 appointees through departmental screening committee, is required to be stayed. Else, it will result in failure of justice. Accordingly, we stay the notification dated 18/8/2025, by which 18/8/2025 issued by the Chief Secretary to the Government of Nagaland, bearing number HFW bracket A 10/34/2024/145 till the next date. This court, we further direct that no further action be taken in pursuance to the notification dated 18/8/2025 till the next.
My lord, my respectful submission, since for 98 operators is introduced completely, then let it be subject to the final outcome of this.
No.
Introduced completely.
No.
So introduced.
If I'm staying here, yesterday I've set aside this notification. Caveat stands the church.
For orders, item number 18.
What are these?
Lord, the IA is for coordination of the, in referring the field, it's in field, 484 days.
Well, this is the first appeal
Yes, Lord. Criminal appeal from Chair, Lord. It's preferred from the.
against the,
Against the conviction.
you are who?
I am the convict.
You are appearing to legal service. Are you a legal service?
No, Lord.
Legal aid counsel?
Yes. No.
Private counsel.
Private counsel for this.
And this is a done under what? 376?
Yes, 376 AB, read with section 6 of the POCSO Act.
Yes, we condone it. That's right. This is an application filed under section 5 of the Limitation Act for condoning the delay of 484 days in filing the appeal against the judgment So this matter has come up for the first time?
No, Lordship, yes.
Or service of notice has been done, na?
Yes.
Okay. For condonation of delay of 484 days in filing the accompanying appeal against the judgment of conviction dated 11/12/2023 and the sentencing order dated 12/12/2023 passed by the learned district and session judge, cum special judge Pokso, Kohima, Nagaland in ZR case number 11/2023. Full stop. We have duly perused the contents of the said application and the reasons so assigned. We are of the opinion that the reasons so assigned constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the application stands allowed, thereby condoning the delay of 484 days in preferring the instant appeal. I stands disposed. Appeal is. We admit the appeal.
Yes, sir. Yes.
And you are appealing for respond number 2. Who, na? Legal counsel.
Informant.
This is an appeal filed under Section 415, bracket 2 of the BNSS 2023, challenging the judgment dated 11/12/2023, as well as the order of sentence dated 12/12/2023 passed by the learned district and session judge cum special judge. So, Kohima, Nagaland in ZR case number 11/2020. Stop. The appeal is admitted. Call for the records. Ms. S. Mary appears on behalf of the respondent number 1. Ms. So-and-so appears on behalf of the respondent number 2 and 3. Stop. List the registry shall prepare the paper book and thereupon list the matter for hearing.
For orders, item number 19.
An amendment?
My lord, yes.
What has happened?
This is the detention where petitioner is challenging the detention order. Now, when the petition is pending before the Supreme Court, the confirmation order has come subsequently. That's why now.
You want to add this?
Yes.
8-1 in
Just
it.
that much.
Heard Mr. Ejo, the learned counsel appearing on behalf of the applicant, petitioner, and Ms. N. Ilalo, the learned counsel who appears on behalf of the respondent numbers 1, 2, 3.
No, only 1 and 2.
Why not 2 and 3? You always appear for 2 and 3.
No, not the advisory.
Huh? Yes, 2 and 3. These are all the government, the state government. Today in the morning, everybody was appearing.
Advisory vote. 2 and 3.
I'm not representing the chairman behind the base, only the chief secretary and the.
Appears on behalf of the respondent number 1 and 2. And Mr. Z. N. Nugli, the learned counsel who appears on behalf of the respondent number 4. This is an application seeking amendment of the accompanying writ petition on the ground that the confirmation order has been passed pursuant to the filing of the instant writ petition. It is therefore submitted that the said paragraph 8.1 and 8.2 that the petition applicant seeks to insert paragraph 8.1 and 8 Roman 2
And paragraph 5 prayer.
as well as 6 amendment as stated in paragraph number 4 and 5 of the said application. We are of the opinion that the said application is required to be allowed. Accordingly, the application seeking amendment is allowed. The petitioner is the applicant is directed to file the amended writ petition within by Monday.
I'll file tomorrow.
Okay, by tomorrow. Within by Monday. By Monday. Full stop. I stands disposed.
Much. For orders, item numbers 21 and 22.
There was a delay of like 5 days, I think.
You are state of Nagaland now.
Yes, but.
Huh?
Yes, but.
What has happened?
Yes.
Which matter is this?
This is.
Delay of 25 days.
Yes.
Who is the other side?
The previous rupees issue, this is being listed for the first.
Huh?
This is for the first time.
Who was earlier appearing? Mr. A.G. Mami.
Each movie is for.
Where is that Mr. A.G. Mami? Anywhere, nearby? Gone?
They may have left.
All left.
They may.
You should have told me early. You could have condoned this delay. Chalo. Issue notice returnable by 6th of October 2025. Steps be taken upon the respond number 1 and 2 by way of registered as well as usual. Madam, this is an application filed for condoning the delay of 25 days in filing the accompanying appeal. The issue notice returnable pensions. We'll take Mr. Application.
For hearing item number 25.
May I please your lordship?
Hmm.
My lord, my lordship, may kindly, I wanted a short accommodation on the facts and circumstances is that my lord has vacated the interim order on 2/4/2025. Kindly see that order, my lord. 2/4/2025.
Yeah,
My lord is there. Kindly come to para 8.
right. We have given our anxious consideration.
No, my lord, this code, bottom of the para, this code, however, observing that if any appointment is made on the basis of the amending act of 19, as well as the amending of 22, the same shall be subject to the outcome of the present proceeding. The affidavit be filed by the state on or before 25/4/2025. The petitioner herein, if so advised, would be at liberty to file reply affidavit. Before parting, we observe that taking into account that this court has not extended the interim order, the respondents shall file their affidavits on the next date so fixed without fail. Now, kindly come to the order of 14/5. 14/5. My lord is there?
So 18/6 they have already filed.
No. My lord may kindly come on 14/5 order. Your lordship's order was of 2/4/25 that you file it within a stipulated period because your interim order has not been extended. Now on 14/5 the matter came up. I raised the objection that the affidavit should have been filed. My objection was recorded, but the matter was adjourned. Now on 18/6, my lord, 18/6/2025, in terms of the order dated 14/5/2025 passed by this court, Mr. Imti Imchong Lanet, additional AG submits that the state respondents filed the affidavit in opposition. Pleadings are complete. List the case for hearing after 2 weeks. So my filing of affidavit in reply was not taken because I was not given because the court has recorded that my pleadings are complete. Your lordship can kindly come to the video recording of 18/6/2025 how the matter was dealt on that very day. Of 18/6/2025, your lordship can kindly see the live streaming.
Why should I see?
My lord, my objections were not been recorded.
Don't make those types of submissions.
Now, Mike.
In terms of your learned submits that the state was they have filed their affidavit in opposition.
My lord.
What has happened? What has happened thereafter?
After that, the matter was listed on 13th of August 2025. I took the lordship's attention to this order, and accordingly I prayed for that. Let me file my affidavit in my rejoinder affidavit. That was been granted, but I must
reply.
Affidavit in reply. So now my request is that why not give me 2 days time? I will file it. It is under the process. I'll file it and post the matter for final adjudication. I will file it within 2 days.
I have a suggestion to make.
Now,
this matter is pending. We filed the affidavit on 3rd of June. For whatever reason, the result was not filed. They took file in August, and now again they want to return. All that I'm saying is that I have raised certain important issues here because he has concealed the fact that he is connected with a political party, regional party, and it was at the behest of that party the petition has been filed. I've filed the press clippings, etc. And as far as PILs are concerned, in accordance with our PIL rules, you have to disclose everything. After conceding this fact, he files the affidavit. So the affidavit on record is patently a false affidavit. I keep the submission aside for the moment. The Lordship would see my
Where
reply.
the statement hereby states and gives the following undertaking to the ombudsman then petitioner
Yes.
and meets imposed.
I filed the annexure also. The paper cuttings. Here it is. My lord. No page number, nothing. Annexure B, my lord. The lordship will receive. Annexure C is shown as the list of star campaigners. Kindly see, madam. Annexure C. My lord has got that, my lord. It's on 2 pages. One is the clear copy. 25th January 2023.
RPP, what is that?
My lord.
What is Rising?
Rising People's Party. It's a regional party. My lord, kindly see. Submission of names of star campaigners. This serial number 6, Licro Creo Secretary Administration RPP. So he is the political man. And strangely, my lord, following page also his name is shown as secretary at Licro Creo 4. And kindly see the press cutting, my lord, at Annexure F. Only one, I am taking only a lordship to Annexure F.
S.
F.
Okay.
My lord of course. Criticizing the Nagaland government's amendment of Local Act, which has happened, the effectiveness of the institution, the Rising People's Party has filed a public interest litigation. So this man has filed it on behalf of this, even according to the same party, which has them themselves have given the press clipping. Whereas in the petition, he is not talking anything about the party, as though he is a public interest litigant and is giving it in his own name.
But is it a part of a person who is in the party?
They have to make a disclosure. The affidavit says, kindly see, the affidavit is there.
Where I so and so, I am the petitioner number 1. You are referring only to the petitioner number 2.
Madam?
But petitioner number 1 has no problem, no?
Yes, serial number 1 may be, but there is a combined petition between both of them.
Petitioner,
And-
the affidavit of petitioner.
And this is the way in which they try to attack the government, putting up a public profile and they specifically said that this petition has been filed by this party through this man.
But
And if you were to see, my lord, kindly see the
But Mr. Advocate, Mr. Buragoy, tell me one thing. Why is your affidavit is not in terms with the High Court rules for former A?
My lord, I have given
I'm not saying anything about as regards petitioner number 1 has filed the affidavit.
yes, my lord.
But why the affidavit is not in terms with the performer A or performer B?
My lord, your lordship is fairly correct. Let me be very clear. When this matter was being drafted and filed, perhaps my oversight might be happen. Let me be very honest to you.
But Mr. Buragoy, kindly appreciate one thing.
My lord.
The registry could not have accepted this.
Exactly, my lord. Exactly. So now question, that's why I wanted to bring everything in my affidavit reply, because I'm not going to conceal anything.
Almost this type of affidavit, how is it possible?
Because there is a scrutiny committee, because for PIL there is a scrutiny committee is there, your lordship is well aware, and the registry also has to verify it. That is the problem. That is the problem which we are facing sometimes in some matters.
Where is the question of registry verifying when they have supplied wrong facts? They have not mentioned it this.
No, that's, sir, that is a question, sir.
He has admitted the mistake.
Sir, that is a question which I can address in my affidavit in reply. I am addressing to the court.
Mister, why you want to challenge it? Why you are not challenging by way of a repetition?
Yes.
Last time also I told you.
My lord, your lordship, that issue.
No, there is no PL. Mr. Bhagwan, last time also I told you. By way of a PL, you cannot challenge a statute.
Your lordship.
Therefore, the question is, why you are not filing I'm not saying that you don't file it. You file it. Why don't you file a fresh one properly? File it by a repetition. It will come up before the division bench only.
No, your lordship will appreciate one thing. My lord will appreciate one thing. What your lordship, last time also, when your lordship was vacating this stay, your lordship has put this query to me. I told the court that my lord, it is maintainable as far as the law is concerned, because the matter where this Lokpal and Lokayukta came up, that matter was itself a PIL, which was taken by the Supreme Court. I will bring these things on record. I will bring these things on record.
No, Mr. Buragwai, kindly listen one thing.
My lord.
Matter when it went to Lokpal area, because of not framing of Lokpal or Lokayukta, the matter went to Supreme Court.
My lord.
But there is no challenge to the provisions of the Act there.
It was asked for the enforcement.
So therefore, the question is, why are you not filing a writ petition? A division bench, when you challenge an act or a rule, it will come up before the division bench. And you don't need all this problem out there. If you are aggrieved, but why are you filing a PIL? I don't understand. It becomes very difficult for a court to exercise the jurisdiction in a PIL where a statute is being challenged.
My lord,
your lordship, my lord, your lordship
he didn't file a PIL in the Supreme Court. He filed a writ. And then after some time argument, they said, we want liberty to come back. When he comes here, he misuses that liberty, files a public interest litigation, and then suppresses all these facts.
No, I have not approached the Supreme Court, sir. I have not approached the Supreme Court. I have not approached the Supreme Court yet.
That is a petition.
No. The petition is, I have not approached the Supreme Court. Your lordship will appreciate that as per the Honorable Supreme Court judgment in PepsiCo, the nomenclature of the petition is immaterial when the courts have the power. It is public interest litigation also. Your lordship is exercising 226. Exercising 226. And if your lordship finds that, okay.
One of them, he has filed the petition, Kiran Paira, and they have not filed the affidavit, the order. I can just read it and pass it on to your lordships. The order says, after arguing for the writ petition, civil number 282825, that's it, petition number, not PI. Then, after arguing for some time, Mr. Vijay Ansari, another senior counsel for petitioner, seeks permission to withdraw this writ under Article 32 and seeks liberty to invoke the writ jurisdiction for the principal bench of Gauhati High Court under 226 permission granted disposed of. So he never filed in the first place the PIL in the Supreme Court. He filed a writ petition. After some time argument, we know what happened. So then generally we withdraw the petition with liberty or a grant. Now he now wants to introduce this as a public interest litigation. And if it was a public interest litigation also, then he should have disclosed all facts. Apart from this, my lord, I have brought today the select committee report of the Rajya Sabha. The select committee report of the Rajya Sabha clearly says that the states can have their own act. Very clearly says. This is on the basis of the United Nations Convention Against Corruption. I got that with me right now. So all these facts are against him. And his allegation that such committee cannot consist of two of us. Most of the states do not even have such committee. I got a list of all that. So they are just putting it in the press, abusing the government.
No, but you are saying all these things, but have you brought on record these aspects? What you are saying, have you brought on record these aspects? Where?
Kindly see, madam.
Huh?
My counter. Kindly see my counter.
Yes. About the select committee?
Let us see.
Guwahati High Court rule.
I've stated in para 13 of my counter. That is running page 10. I'll do it one by one. My lord has got that, my lord?
Yes.
We reference the such and such respectively, which primarily deals with the composition of the selection committee and the qualification required for appointment local. As far as the selection committee is concerned, there is no law that the selection committee in the Lokpal and they have to be identified. Incidentally, many of the locals have asked pertain to different sites, they don't even have a screening committee. Role of the screening committee is limited to forwarding the names of the candidates after scrutinizing the application. That's it and nothing more. Then, my lord. Then at page 17, para 22. Legal question. The most of these allegations are repetitive. Present petition is not maintainable either on law or facts, same or motivated, and no challenge to the constitutionality of an act may challenge in a public interest litigation. This is settled by the Supreme Court itself, my lord, in Guruvayur case, that famous temple case in.
No, that I know, I was telling him
With that,
the last occasion.
so now they want to make it a PIL and expose a public cause. And if you lift the wheel, it is clear that they are a regional party and he has accepted that it is a mistake, that it is oversight. You cannot escape from filing a wrong affidavit saying it is oversight. You've been attacking the government right, left, and center. That's not correct. Petition is not maintainable on the face of it, my lord. You cannot file.
But what do you say? If we convert it into a writ? If we convert this into a writ?
He may have to.
Then?
He may have to file a separate writ.
Why?
Because as far as the ingredients of PIL are concerned, they're completely different. So no loss will be costing. The right position would be, in one such case, if he's going to file a separate writ, his purpose is served, he gets out of many of these things. So that will be slightly in compliance with law. I leave it to your lordship.
Mr. There are many cases where the PLs are sometimes when it is seen that it may not be exposing the public cause, or there has been, in fact, they have registered it wrongly as a PL, they should have, in view of the affidavit, should have registered it as a writ petition.
But in a case like this, where he suppresses facts, files a false affidavit, misleads the court, misleads the government, would it be proper to convert this petition in pictures of things? The least that can be done is, if you want, you can withdraw it, file a fresh petition. That would serve the end of justice and no prejudice will be caused. I leave it to your lordship. But on this petition, he cannot
Mr. Prabhu, why are you not filing a writ petition? I give you the liberty to file a writ petition, challenge it. I give you.
Your lordship, if I bring, I understand what you, I understand your lordship.
Without going into anything else, last time also I told you one thing. I've seen many judgments of the Supreme Court also.
My lord.
Review the PIL, you cannot challenge a statute. Challenging a statute has to be by way of a person.
My lord.
If you are aggrieved, you can challenge it.
But your lordship can convert it this into into writ. Thoxom's, it is Pepsi Food Court judgment. Nomenclature of the petition is not material. If the power is there and the issue is there, lease is there, that can be converted because your lordship will appreciate. PIL is just a nomenclature. But the exercise which your lordship is doing is under 226, where the scope is much more wider. That's why the Supreme Court in Pepsi Food Court's case, my lord, your lordship may kindly come to that judgment.
Let his client file an unconditional apology for making.
No, I would say,
I will leave it at that. You can't go thought-free.
no,
That-
no,
the
why,
court-
I am not, then you wait for my rejoinder. My lord, may I have the Pepsi Food Court judgment, your lordship?
Lordship, what you see my counter affidavit at page 8, I have incorporated every pending to page 8. Para 12, my lord. My lord got that, my lord? May I read it? That with reference to para 6, the same are not obtainable and has been made under the wrong exception. Lower Fifth Act has to be a carbon copy of Local Act, underscoring the fact both these acts apply in different areas by different legislatures. In this context, it was further pointed out that even the United Nations Convention Against Corruption by Article 6 has stated, implementation of the convention in the member countries may be subject to their internal laws. The report of the Select Committee of Parliament states the states are to have absolute freedom in determining the nature and type of the institution of Lokaita, depending upon the needs and requirements. In
But,
view of the consensus.
where is he? Mr. Buragua, tell me one thing.
My lord. My lord.
Tell me
Sorry,
one.
sorry, so
that
sorry.
File, you see the difference between a PIL and a writ petition is this. In a PIL, once you satisfy the ingredients of a PIL, locus standi is waived. However, in a writ petition, you have to be a. Isn't it? Isn't it?
That's it.
Is the difference between PIL.
That's
Once you
absolutely correct.
satisfy
Absolutely
the
correct.
ingredients of a PIL, then locus standi is waived. Whereas you can do so. But Mr. What do you say about Mr. Advocate, what do you say about the judgment in SP Gupta, wherein it gives still the liberty to a person challenging an act which on the face of it is in violation of the but that is not a violation. Here it is not the violation of a
No,
basic structure.
Not at all, not at all. He just came the PIL to jump out of many things. Now when he's caught, he's still giving, your lordship is giving the opportunity. We don't, but he's still resisting. That's very sad. But jump at it. Otherwise, this petition can be dismissed. There's nothing in this petition.
Yes, where is the judgment by which a PIL cannot be filed against challenging a state?
My lord, am I audible now?
Yes, very much.
So sorry, my lord. Your lordship, as far as PIL, what your lordship was pointing it out, I agree to that. My lord, may bear with one word, one sentence which I would like to read it down. In Pepsi Food Limited, 1998, 5 SCC 749.
Kindly see the flagged portion.
My lord?
Guruvar, there was some dispute in the question of investigation, all these things said. So the court has said that High Court cannot have passed.
This was said in this Narmada Bachawala.
Kindly see the flagged portion. I've underlined that. Exactly.
Yes, what are you referring to?
My lord, may kindly come to the judgment if your lordship have that one, Pepsi Food Limited versus Special Judicial Magistrate, 1998, 5 SCC 749.
What does that have to do here, Mr.?
My lord, that's why your lordship, what I am proposing is that,
Wait.
Let me be given 2 days time. I will bring my affidavit in reply on records.
No, first.
My lord may fix the matter day after.
Mr. Buragua, I give you an opportunity to withdraw and file a writ. If not, if you insist, I dismiss your PIL on the ground that you are challenging it, giving you liberty to file a fresh one. Which one do you want?
Can it be posted, my lord, can it be posted for tomorrow? Let me obtain the instructions.
This, don't take it to be like that. If I am going to do either of it, I'm giving a good opportunity to withdraw with liberty to file again. Second opportunity is filing a writ petition, dismissing it that you cannot maintain a PIL to challenge it. Which do you want? Either of it. I am not going to touch any affidavits, all these things. But the fact that this affidavit, this was wrongly done, it could not have been done. You file a fresh one. What is wrong with you?
Well, in that case,
now you know, now Mr. Buragwai, you know also what is the stand of the respondent.
My lord.
Better your petition.
Well, in that case, first option. First option.
First
option.
Okay. Heard Mr. S. Buragwai, the learned counsel appearing on behalf of the petitioner.
Buragwai, my lord.
And Mr. K. Balagopal, KG Balagopal, the learned senior counsel, as well as the Advocate General of the state of Nagaland, assisted by Mr. Imti Imsong, the learned counsel appearing on learned additional AG, state of Nagaland. The learned counsel appearing on behalf of the appellant, a petitioner submitted that in view of the judgment of the Supreme Court in the case of Narmada Bachao Andolan versus Union of India 2020 10 SCC 664, the petitioner would not like to pursue the instant PIL, the public interest litigation, in as much as the Supreme Court in the said judgment had observed that a statutory enactment cannot be challenged by way of a public interest litigation. He, however, submitted that the impugned enactment which have been challenged is required to be challenged in the interest of justice. So the petitioners may be granted the liberty to
prepare a writ petition.
File another petition to challenge the same by way of a separate writ petition. Full stop. Because I cannot allow you to withdraw now, I have to close it and then
yes. Yes. Dispose it off.
This court having also taken note of the submissions made by Mr. KG Balagopal, the learned Advocate General for the state of Nagaland. Full stop. A perusal of the public interest litigation as has been filed by the petitioner appears to be not in the format in which the Gauhati High Court rules specifically provide. The affidavit also is not also in consonance with the rules of the Gauhati High Court. Under such circumstances, this court, apart from that, the petitioners have by way of the public interest litigation have assailed a statutory enactment which cannot be permitted. Considering the above, this court therefore drops the instant public interest litigation in view of the defects in the form of filing of the public interest litigation, as well as the challenge being made by way of a public interest litigation to a statutory enactment. Liberty, however, would be there upon the petitioners to assail the said enactment, the impugned enactment, if so advised. And if so advised, it is observed that the said liberty so given is subject to being permissible under law.
My lord. My lord, as Buragwai.
As Buragwai or Buragwai?
Buragwai.
My name may be correct as KN, not KG.
Oh, okay.
Even I've given my learned additional AG's appearance also.
No, I admit it.
But I must say, if your lordship permit me, Honorable AG, sir. Today in the live streaming, I believe there was more glow from both of my lords. Going like okay.
For
How
hearing
nice, my lord.
item number 26.
Leave God.
So at last, Mr. Advocate General, I could take up your matter and finish it.
I also was very comfortable watching the proceeding and some of the ineligibilities of the government.
Yes, we are paying, what is this? Writ petition challenging what?
Rules, man.
Which rules?
School education department rules. The petitioners are the regular teachers of school education department. They are challenging the rules 50 of the rules.
Mr. Joe, this will take some time, no? So we have on thing, if I'm coming for 2 weeks, we can take it up. But tomorrow I'm leaving if you wait.
Lordship, in that case, the interim order may be vacated, Your Lordship. Because on the last occasion also, there is a court order saying that no further adjournments, and if adjournment is taken. Lordship, because if we look into the matter, Your Lordship, the petitioner they do not have the case, Your Lordship, and some of the petitioner has already.
No, first of all, tell me what is the rule?
It's regarding with the limited.
No, what is the interim order passed?
They have stayed the advertisement for appointment of assistant headmaster. Your Lordship.
Advertisement dated issued by the Nagaland inviting application of so and so under school education department shall remain stayed. Why?
For that matter, Your Lordship, the school is facing difficulty because of not having the junior education officer as well as assistant headmaster.
No, but why this order is being passed? Means when the rules are there.
Yes.
How can the order by being passed? Yes. What is the thing the petitioner is assailing?
They are challenging the service rule, but they never annex the service rule also, Lordship. And it is only the petitioner who are aggrieved, Your Lordship. There are more than 3,261 graduate teachers.
Provisions relating to reservation of 20% of all vacant posts of junior so-and-so in a calendar year to be recruited through nominated demand as fine mentioned in so-and-so rules should not be declared ultra vires. To set aside and quash the impugned advertisement dated so-and-so. You issue mandamus directing the committee constituted by the respondent to review. Not given. So what is the advertisement?
The advertisement is at page 40. It is for the post of 56 vacancies of assistant headmaster and junior education officer.
Page?
40 of the writ petition, Lordship.
Applications are invited for filling up of 56 vacancies of assistant and so and so, graduate teachers so and so. Why you are, Mr. Joe, you are challenging this advertisement?
Because that was issued in terms of Rule 15. Rules 15 provides that for the post of assistant headmaster in high school can be appear by both graduate teacher as well as primary teacher. So here basically we are challenging Rule 15 for it has resulted in total disparity in matter of promotion.
But this is as per the rules.
Yes,
that's why we are challenging the rules.
But if the rules is in play, there is no stay to the rules. Then how can you challenge these rules?
Well,
advertisement
rule is under challenge.
No, this rule have not been stayed.
Yes,
the rule is in full play. Then how do you challenge the advertisement? We may say any appointment so made shall be subject to outcome.
Yes,
this can be disposed of today then. I don't know. In that case, this matter may be disposed of today itself.
Oh, I'm a very bad judge on rule challenging. Don't take that here.
Your Lordship, some of the.
Let them go ahead with the advertisement.
Yes, Lordship.
Any appointments
My
will be
Lord.
made, because Mr. Joe kindly appreciate. When a rule is being challenged, unless the rule is still in play,
Yes.
any consequential, unless you say that this advertisement is contrary to the rule, then it's a different thing. Can you say that?
Lordship, my humble submission. Once the advertisement is allowed, then petition become infractions.
No.
Partly.
No.
Partly in the sense, why?
No. Therefore, I'm saying any appointments they have made shall be subject to the outcome.
Yes. Lordship, yes.
That is what I'm saying, because you see, the main problem which applies is, first, there cannot be a stay to the rules. The rule is in play. With the rules being in play, the advertisement is, if it is not in conflict with the rules, question of staying the advertisement does not arise. So let them go ahead. You want to participate, you can participate. And then it will be subject to the outcome.
Yes, Lordship, next week, Lordship, I'll be out of station, Your Lordship, so.
That is the,
Yes.
in that case, I'll be very fair. If not today, wait till they fix the matter.
No, my Lord has suggested.
So that,
staying
so that no injustice, no prejudice because.
Okay. We
Wait till
still,
they
have,
fix.
we still have 45 minutes. Argue.
Yes.
But that's better, man. My Lord, I have just prepared short summary of its facts. Summary of the case. I'll just, so that it will be easy for the Lordship to understand. Well, I'll just read it. 1. WPC number 171. Lordship.
So what is your ground of challenge?
My ground of challenge is that I have page 3, basically page 7, number 7, para 7.
No, what is your ground of challenge to the rules?
This is the ground of challenge to the rule is that by incorporating this.
No,
it places two unequal-
Mr. Joe, the challenge to the rules has to be on the, if it is ultra vires the act.
Correct.
Or
It is-
ultra vires the constitution.
Correct.
Or if it violates the fundamental right. Where is it?
So now.
There is nothing mentioned, Your Lordship. There is nothing mentioned in the petition, Your Lordship. Even the incompetency of the rule-making authority, nothing. He has never shown as to how his fundamental rights has been violated because of the Article 15. Everything because of that.
Mr. Joe, you may find a better judge next week or day after, and who may pass the good order, but for me, I think we should vacate the rule.
Yes. Lordship, this is ultra vire. So
I don't want to dismiss your last matter. If it is, this is the last matter. Last matter, no? Last matter of the day.
let it be on next.
Lordship, but this is the matter, Your Lordship. Otherwise, this has been dragging since 2022, Lordship, the matter.
The challenge to a rule is very specific.
I have shown two judgments which support my case. One is All India judges case, where Supreme Court had laid down the principle that to give promotion to the class 1, grade 1. Board should be the civil judge senior division board. One is normal promotion, one is the limited departmental promotion. I have this, I have shown here. In the items. Now, therefore, in this case it's contrary because one is primary teacher, entry point is different, qualification is different, entry point is different, graduate teacher, qualification is different, pay scale is different. Now, then the main thing is channel of promotion is totally different.
So your challenge is Rule 15, na?
Correct. Channel of promotion is different because for the post of graduate teachers, they can raise up to
20%
director.
of all the vacant posts of junior education officers, assistant headmasters in a calendar year shall be reserved for recruitment to limited departmental exam from amongst the graduate teachers, primary teachers. And those holding equivalent post with 50% marks relaxable by further. So you are against this 20% reservation?
Yes.
Why?
Yes, because that is taking away our quota. Because Lordship will see.
So recently the Supreme Court in the recent judgment, have you looked into the recent judgment? 2025 SCC online?
No.
Then you don't have a case.
My Lord, Lordship will
There also the Supreme Court says there should be a limited departmental examination. This is just for the purpose of boosting the morale.
LDC.
Under the rules, under Schedule 2,
They are doing something. Now the Supreme Court is bent upon asking the High Court as well as the state government to amend these rules in view of that All India Judges Decision case. That it categorically says that you have to have 10% out there or so and so percentage out there in respect to everything. Then notice.
if you look, that is, if we look at the service rules, the entry point is for primary teacher. Next promotion is primary teacher grade 2. Then the third promotion, second, primary teacher primary grade 1. Last promotion is area education official.
Junior education.
Area junior official.
That's a different post.
That is the last post for primary teacher. In our case, as per Rule 2, the Schedule 2, our promotion, the entry point for graduate teacher. Then the next promotion is senior graduate teacher, assistant headmaster, deputy director, joint director. So therefore, my main contention is this. When primary teachers entry point is different and they have their own channel promotion, unless this is amended. We have different channel promotion, different entry point, having different qualification, having different pay scale. Everything is different. So therefore now, by incorporating this Rule 15, the primary teacher.
So you are all graduate teachers. You are all graduate teachers.
Very much. All senior graduate.
Your entry point is?
Into graduate teachers.
Is graduate teacher, that is 70% by direct recruitment, 30% by lower degree.
Yes.
Qualification, graduate, postgraduate or equivalent.
That is where primary teachers.
Pay band 5,200 premium, grade pay 3,400.
Yes.
Then primary teacher.
Yes. Page 3.
Are
entry point, page 3.
Entry point is primary teacher is entry point.
Page 3 in my summary of the case.
Primary teacher is what?
Plus 12.
It is a direct recruitment.
Yes, direct entry point.
So anybody who have passed class 12 or equivalent or graduate is to be appointed as primary teacher.
Eligible. Class 12.
Now by this rule, these people, the graduate teachers and primary teachers are being given an LDCE.
Yes.
To go to the post of junior education officer or assistant headmaster, thereby reserving 20%.
Yes.
Okay. Now you are graduate teachers.
Correct.
So what is your problem?
My problem is, see, Lordship will see entry point 70% direct for all of our graduate teachers. 30% is open for that lower grade people, means primary teacher, means entry point. That was taken away. So out of 70.
Now you have a chance. Why you are not appearing in the examination?
My point is, by incorporating this, it is making the unequals equal.
Why?
Because 100% different, collection is different, entry point is different.
And the
different
entry
channel
point of
purpose.
what? Of entry point of?
Entry point for us who are graduate with higher scale, higher responsibility. Primary is to
No,
teach
no,
the primary students.
No, these people, the
Yes.
graduate teacher as well as the primary teacher,
Yes.
they can go to junior education officer oblique assistant headmaster.
No, not for primary teachers.
Huh?
Primary teacher up to senior area
Yes.
officer.
Primary teacher, entry point primary teacher, then I have given here in the schedule.
From among, no, 20% of all the vacant post of junior education officer, oblique assistant headmasters in a calendar year shall be reserved for recruitment through LDC from amongst the graduate teacher oblique primary teacher.
Correct.
And those holding equivalent post with 50% marks relaxable by 5% for scheduled tribes or year, differently able so and so, and who have served at least 10 years of continuous regular service as graduate teacher, oblique primary teacher, oblique equivalent post. So a graduate teacher can become a junior education officer.
Yes, that is promotional.
And the primary teacher can become an assistant headmaster.
No.
Then what does he become?
They can become, the primary teacher also, they can become the junior education officer or assistant headmaster.
So they can join both.
It is a competitive examination.
No, by
It is
LDC, Lordship is asking whether in the normal track.
Yes,
In the normal track.
They have to wait for the term for promotion. But this is an accelerated promotion. Instead of waiting for the normal term, they have to compete. in
Jump
the-
promotion.
Yes.
Jump
Yes,
examination.
yes. So we are not looking at the entry grade. We are only concerned with the educational qualifications.
Then what about the qualifications? One is
Qualifications is-
graduate and one is class 12.
No,
Right.
if the primary teachers who has the graduate degree, they can apply.
Okay, that's the provision.
Yes, yes.
The primary teacher has to have a graduate degree.
They should have a graduate degree, then lordship, they should have either BA, PSCE or DLA, and they should have 10 years of continuous regular service.
And graduate also.
Graduate also, lordship. So they are in the same class, lordship. So there is no discrimination, no unequal has been treated as equal, lordship.
Mr. Council, as I understand.
Yes.
You are not so much aggrieved by the LDC scheme, but more by the fact that in the LDC scheme, the examination scheme, the graduate teachers are having to share that quota with primary teachers.
Absolutely.
Right?
Because lordship will see the more normal promotional process is out of 100, like I say, entry point, 730 has been given for the Loudman primary teacher. Though they can enter directly through recruitment process. Now 70, those of us who have entered directly through graduate, their next promotion is assistant headmaster. So if that is given through limited department promotion to the primary teacher, then we have been blocked. We are waiting in by way of seniority.
But this kind of block means they
You can also compete.
for the purpose of morally.
I understand about that.
You can
Limited
also
department
compete.
exemption, I understand that. Now, that's what I'm saying. In the All India Judges Service Matter, Supreme Court has laid down that. So I will just Supreme Court has laid down the principle that the feeder grade should be same. Not from supposing there, my lord will say, for the grade one, to be promoted through limited departmental promotion is both has to be from the civil judge senior, whether it is junior or senior in the same grade, whether it is junior or senior, same grade. Not that
you mean to say you have no problem in the LDC if it is only done from the graduate.
Correct,
That's it.
absolutely,
Because primary teacher
much lower.
and who has a
In grade.
promotional avenue to
Yes.
go to the graduate teacher.
Yes, that is what Supreme Court said in the All India Judges case. Lordship will see appreciation in All India Judges case. If Supreme Court held that even the magistrate first of all, civil judge junior can also participate, then I agree that I have no case. I have no case. If Supreme Court held in All
But
India
has the
Judges.
Supreme Court said out
No,
there?
that
Yes.
principle has not been laid down. That different grades cannot participate together in an LDC.
Lordship, I'll just read out this.
If I'm not mistaken.
All India judgment. This is SEC 2002 volume 4. Just last paragraph 28. What I'm trying to lay the ratio is this. But I'll just read one paragraph only. Lordship thinks that there is no time. So, page 28. Paragraph 28, page 270. Page 270, paragraph 28. The principle has been laid down here. Paragraph 20, may I read it, my lord? As a result of the aforesaid, to recapitulate, we direct that recruitment to the higher judicial service, that is, cadre of district judges will be 1A, 50% of by promotion from among the civil judges senior on the basic principle merit seniority and passing of. This is normal selection process. B, 25% by promotion strictly on the basis of merit through limited competitive examination of civil judges within senior division is not.
No, Mr. Joe, this is what has been given by the court. But is it that saying that a person who is not equal in rank, a person, there are two persons, so just for example, is it a proposition of law which you are trying to say that a graduate teacher as well as a primary teacher being of two different ranks?
Yes.
They cannot be given the benefit of LDC to go to assistant, the junior officer or assistant headmaster.
Correct, directly.
Your submission has to be backed by some law because the parameters on which the selection will be carried out to the post of assistant teacher as well as the junior officer, whatever may be, is on the basis of purely on merit. Having equivalent 50% marks and so, and having passed graduate, thereupon going through an NPSC recruitment, wherein they have to prepare for all these examinations and so. Now, the Supreme Court, in the context of this case, said that we make the senior division to appear for the purpose of district judge.
Grade 1.
That is it. Now, recent judgment has also come whereby a person who is in the junior division is also given an accelerated promotion to
Not
the
junior,
senior division.
not junior, man. Senior division,
No,
not junior.
Junior division to grade 2.
Grade 2, they have given.
10%.
This is the latest judgment. 2025 SCC online 1485 or something. That is the recent judgment. But my question is that what stops the state to carry out because here primary officer, whatever it, these people they have to have minimum 10 years or some work period of work they have to do. This particular person, 10 years, both.
Graduate also.
They have work as for 10 years. Let me see where the 15 is.
Lordship, affidavit of opposition page 7.
It's okay. They have to have at least 10 years of continuous regular service as graduate teacher or primary teacher or equivalent post. So they have to have minimum 10 years of service. Now, a graduate teacher may very well become a direct recruit also. 70, 30?
Direct. 70 direct.
Another person, a primary teacher is 100% direct recruit.
Correct.
Both are graduate. Both have to be graduate to come under 15.
Correct. In service. In service.
No, they both have to be having graduate degree. See, degree, postgraduate level with B.Ed, PhD, DEL, Ed, and who have served at least 10 years of continuous as graduate teacher, primary or equivalent post. So they have to have a similar type of educational qualification also. Now they have to then appear before the NPSC, where a similar set of new paper will be held. So now, if they are doing this, what is wrong? Where is the violation of fundamental rights?
My submission is equality under the law should be among the equals. Now, supposing graduate teachers, whether junior or senior, depending on their performance, if they participate in limited department exams, I have no evidence. Even I'm waiting that among the equals. Among the equals, if all the graduate, junior, senior, anybody, because this is to accelerate the promotion. If it is only within graduate teachers, who enters graduate, junior, senior, I have no defense, because that will be equal among the equals. But equality cannot be between equals and unequals. This is my point. Now, Lordship, there is one judgment, Sukantala. Yes, there are similar principles. These are Himachal Pradesh High Court rules. So there, I'll just show. Now, my Lord, and before I come to that, now Lordship will see in my write up, Lordship must have seen page 4. Page 4, paragraph, starting from paragraph 10, 11. The latest provision. Representation seeking for review of the Rule 17. And on 24/4/18, all Nagaland Teachers Association has filed representation seeking for review of the Rules 17. And then check 1, page 30 to 37, is repetition. B, on 29/1/18, review meeting was headed by the Chief Secretary Nagaland and 3, page 38 with the repetition. C, on 26/3/18, a review committee consisting of 9 members was constituted to review the service rule 17, and then 4, page 39. 12, pending review of the service rules. The implement advertisement dated 21/7/22 was published by the Secretary NPSC to fill out the vacant role of Assistant Headmaster JEO through limited department examination in terms of Rule 15. So now this is the factual position. Now they have already constituted a review committee because they came to know that there are a lot of discrepancies.
But Mr. Joe, these are facts by which a rule cannot be
Just to show
changed.
that fact.
Let us see Sakuntala.
Which, if Lordship have the patience to read, it is short judgment, almost similar. If we start from paragraph 3, page 4/12, 11 paragraph start from page 4/13, paragraph 3, factual things. Then the relevant paragraph is paragraph 12, 13, 14. Here, the rule was challenged. Himachal Pradesh High Court rule was challenged. Because by rule 10, the unequals are making equals.
This is a normal promotion or?
No.
This was a exam promotion.
Yeah. Purely on the principle of violation of Article 14. Particularly, when 2 unequals are making equal, it violates Article 14/16. Therefore, it is ultra vires and unconstitutional. So same with here, same here. Relevant with paragraph 12, 13, 14, but facts are more or less same.
But in this case, the promotion from the other category, wasn't it made to the exclusion of for the original category?
Therefore,
Isn't it?
therefore they challenge it. By which?
But here, both can participate, right?
Even here, rule 10, by incorporating rule 10 of 1992, the 2 unequal have been made equal. So therefore, it is violative of Article 14.
But this is it is not a person thing by which these people were selected for promotion on the basis of a normal course of events. Putting two unequal cadres together for the promotion to the post of a particular thing.
Superintendent.
Or whatever you mean. But here is a case where the primary teachers as well as the graduate teachers who are having 10 years of year are asked to appear in an LDC for the purpose of promotion to that. And this is being taken on the basis of purely on merit, subject to being qualified to have a degree or so and so. So therefore, if we see this is a different concept of LDC is a different concept.
I understand.
By which these people are given an accelerated promotion, taking into account for boosting the best. Sometimes what happens, a person may miss out the chance in a graduate teacher appointment. And this person concerned have applied for the primary teacher. He may be tomorrow, he may be a PhD also. He may be doing so because he wants a job. Tomorrow, when a chance comes in view of this, so that these people can be brought to a particular level and purely on merit, then what is wrong?
Now, my lord, in the same rules, there are two different channel of promotion. One is ours is elementary secondary, one is higher secondary, that is for postgraduate. In case of postgraduate, they also have different channel of promotion. For us, graduate, different channel of promotion. There in postgraduate, no such limited departmental examination is held. It's not provided for that. In case of graduate teacher, postgraduate teachers.
These rules are for whom?
For all of us.
I'll show a very broad submission. Under Rule 12 also, he has the chance to be promoted as postgraduate teacher, provided he has the postgraduate degree. That is Rule 12. Rule 12, that is a wrong misleading submission submitted by learned friend.
That's a wrong submission.
If you read the Rule 12,
Rule 12 read with Schedule 2.
30% of the posts are reserved for them.
Correct. 30% are reserved for the graduate, primary, for postgraduate at the time entry point. To Rule 12, conjoint reading of Rule 12 and Schedule 2. That's a wrong submission. Maybe she has not gone through properly. So therefore, I'm aware of that reply. Therefore, I'm aware of this. Rule 12, conjoint reading Rule 12 and Schedule 2 always show 30% of postgraduate reserved for the lower feeder. They can compete. Even in our case, graduate also 70 direct, 30% reserved for lower grade. That is understandable. That is not the case. So therefore, in case of postgraduate, there is no provision which prescribe limited departmental examination. So why only for graduate posts? If that is the case, then why don't we also allow to participate in limited departmental examination for the postgraduate then? At that level. So therefore,
That's a matter of
Lordship has understood
policy in the rule.
my point that if by, like I say, unequal cannot be made equal. That will always violate Article 14. Equality has to be among the equals. My submission, equality has to be among the equals. Now, therefore, in this rule, Rule 70, like I say, only in respect of graduate promotional channel of graduate, not in the promotion channel of postgraduate. So therefore, why discriminatory? Why arbitrary provision? Why it is not violating from Article 14, 16? That's my argument, madam. Equal should be made equal. Unequal cannot bring and make equal. That will obviously violate Article 14. This is what my humble submission.
So your therefore submission is that a graduate teacher who is higher in rank to the primary teacher.
Correct. Even general promotion.
And in fact, the primary teacher is the feeder post to the post of graduate teacher. Is a feeder post?
No, normally it's not. Their last promotion is area senior area education officer. Their last promotion, normal promotion.
No. Feeder means how do you see 70-30 is the graduate?
Yes.
70 is by direct recruit.
Yes.
And 30 is from where?
Correct. From lower grade.
What is the lower grade?
Lower grade means language teacher, physical teacher,
Primary teacher.
primary teacher.
So therefore, I'm saying, primary teacher is a feeder category of, is a feeder category post to
30%.
the post of graduate teacher. So your submission is, why a feeder category teacher post, a person who is in the feeder category
Yes.
is permitted to compete with a graduate teacher.
Jumping 4 stages.
Graduate teacher for the post of assistant master or the junior education officer. There is no competition between equals. That is what you are saying. But the fact remains, as again I'm saying, this is a particular, it is an LDC by which these are preference being given. This is not a preference. This is an merit is being looked into only for the people, that those persons who are lower down in the rank, but having not got an opportunity, but actually could excel in top posts, are given more opportunities on merit. But they have not done for everybody. They have still kept 80%.
So accordingly, the petition, the pendency of this repetition, petitioner number 2, 3, 4, 1925, 40, 42, and 43 were already promoted on the basis of their seniority.
During the
Yes. So
and
your
after
lordship,
getting a
this could be
stay.
brought. Yes.
After getting a stay.
Yes.
No.
Yes,
That-
lordship.
that-
Yes, they have been promoted,
That
your
is
lordship.
through normal process of selection promotion. Now, lordship will see, may kindly come to service rule page 13.
Just a
report. City commission. That is good. But there is no adequate merit. But the question of merit actually city commission of and there was no proper contribution by the voters. It was going to be helpful. Like,
I'll just try to give you an analogy, subject to correction. Is that suppose there is a sub inspector of police in Nagaland police, and there is a constable in Nagaland police. Both have equal qualification, graduate. Both are graduates. Both of them compete for the civil service examination, and both of them become DSP in Nagaland police service. So they're unequals. Their ranks are different, but both have competed and come to the same point.
I'll come.
Would that amount to treating, making unequals equal? They become equal, but they started as unequals. I don't know. As I said, subject to correction.
Lordship, may kindly permit just come. Lordship,
yeah, please.
Page 30 rules, where the method of recruitment for the post of postgraduate under the same rules. Method of recruitment by way of promotion under the same rule for the postgraduate. I keep saying injustice has been rendered to given to graduate because for the postgraduate or higher secondary education, there is no such limited department exemption by which allowing the feeder grade or allowing other people to come and participate and contest, get promotion, further promotion in the case of postgraduate, higher secondary education. Why only to graduate? Because under this.
No. Why only to graduate is not the question. Why only to the post of
headmaster, assistant headmaster,
junior education officer or assistant headmaster,
correct.
Which
Now,
is where you are the feeder.
Yes. Even here, postgraduate. Lordship, that's why I'm saying page 30, 31. For the postgraduate.
Who makes these rules?
That's what I committed to amend the rules. Till now, they have not done. So now
the department, it is absolutely, these rules are 309 rules. having statutory effect. Now we close it.
Lord, you will see here. That's why.
Mr. Joe, enough.
Now,
I think we don't have the time to dictate it, but otherwise, see.
as per my, in my humble submission.
Now we have got, Mr.
In the
Joe,
case of postgraduate.
Mr. Joe, let me formulate. What is your submission? You say that the post of the graduate teacher is higher in rank of the primary teacher. Rather, the primary teacher is a feeder post to the post of graduate teacher. But what they have done, they have eaten out 20% of your right to go and be promoted to the post of the assistant headmaster or this junior education officer, and thereby treating the junior officer or the primary teacher as well as the graduate teacher in a similar manner. You say that as per Article 14, equals can only be treated equally. But these people are not equal. And as such, this classification is not a reasonable classification. But the problem with you is, where is the intelligible differential? The intelligible differential is in their favor.
Intelligent differential. My lord, if go back to Rule 50.
Heard Mr. Joe, the learned counsel, appearing on behalf of the petitioners, and Miss B. Sukroi, the learned additional advocate general, appearing on behalf of the respondents. Will start hearing complete, judgment reserved.
But
We'll give it, we'll take this. Single bench. Single bench, we'll have it tomorrow. Because I have a meeting at 4:50. Okay, we'll have it tomorrow. Just put it tomorrow. Huh? Yeah. Oh, I forgot, actually. Sitting with my brother for the first time, I forgot. Okay. Yeah.